7th, 2019. First of all, can I ask, can people in the back hear me? Thank you. Second, can I ask, is this meeting being recorded? Let me put public on notice this meeting is being recorded. Finally, may I ask please for everybody to turn their cell phones off or put them on silent, including the commissioners and the commission staff. Let me make sure I've done this myself. Notwithstanding the sign behind me, we are the Cannabis Control Commission, not the Gaming Commission. For those of you that came for a Gaming Commission meeting, I'm sorry. We're not going to be talking about gambling today. That's sorry, Commissioner. I'm going to get right into the agenda. We have a lengthy meeting today, so I'm going to just get right into the agenda. We're going to go through the standard process of updating minutes. I think we have 3 sets of minutes from previous meetings to update the Executive Director's report on the status of our licensing for both medical and adult use. We have several licensing recommendations from our staff to take up: 1 change of ownership, a large number of renewals, final licenses, and provisional licenses. Additionally, we have several topics of conversation for the Commission to discuss and vote, including an update on our energy guidance, a report on data availability, which I think is very crucial, and then 2 items relating to Executive Director compensation and goals for fiscal 2020. So pretty packed agenda, and then on top of that, I'm exercising my right to add to the agenda based upon something that came up that I was not aware of at the time this agenda was released. And so we will talk about Judge Wilkins' ruling with respect to vaping and what, if any, actions we will take in response to that ruling. It does qualify as something I was unaware of, notwithstanding State House News reporting that I was leaving the State House at 11:45 a.m. on Tuesday. I was indeed leaving the State House at that point in time, but it was with for a meeting that had been scheduled way ahead of time and had nothing to do with vaping. When I left that meeting is when I learned about Judge Wilkins' ruling, and our agenda had already been distributed, so it's something that I was not aware at the time. So we will discuss our response to Judge Wilkins' ruling. With respect to the media and the public that are here, because they anticipated that we would talk about Judge Wilkins' ruling on the vaping ban, I'm going to put that at the beginning of the agenda. We will do that first before we get into the rest of our standard business. What I would like to do is go through that, and I'm going to talk about how I'd like to proceed on this topic. We will then take a break. To the extent that the media is interested in speaking with me or any other commissioner on vaping, we will do it at that break. We will not respond to questions without anything else on the agenda, but we will be willing to respond to questions with respect to vaping. We'll then go back after the break into our regular agenda, and then we will have media availability at the end of the day for all other topics besides vaping. So I hope that is responsive to those of you that are here just for the vaping conversation. With respect to the vaping conversation, the way I'd like to proceed on this is as follows, and I welcome the comments from my fellow commissioners if this doesn't feel right to them, but what I would like to do is start with asking our general counsel to give an update on litigation, and not just Judge Wilkins' ruling, but the current status of litigation since appeals and requests for stays have been filed. So I know that all the commissioners have read the ruling very carefully. I still think it'd be useful for the general counsel to go through it, just make sure we all have the same interpretation of the implications of the ruling, and as well for those of you in the audience that haven't had a chance to read through the ruling. So we'll ask the general counsel to start with that. I then would like to ask the executive director to speak and give us his thoughts on how to proceed. He is in the best position, in my opinion, to do so, given that he has had the opportunity to work with staff, obviously, but also because of the open meeting law, he's been able to solicit input from each of the commissioners. None of us have been able to do so because of the open meeting law. So I would like to then turn it over to the executive director based upon input from staff and from his conversations with the commissioners to talk about a path forward. And I would request that we let Sean go through that in its entirety. And once he's done, then I think it's time for the commission to discuss. And agree on what was quote. So if that's okay with everybody in the commission, that's what I'd like to proceed on this. Great. So I'm going to turn it over to you, General Counsel, and if you provide us with an update on the litigation and the current status, that would be great. Thank you.
Thank you very much, Chairman. As an initial matter, I'll just...
And I think you'll be within a couple minutes of the microphone, please.
Thank you. Can you hear me? Okay.
Yeah, go ahead.
So just as an initial matter, I'm going to place the recent order in the context of the overall litigation so that everybody's in the same place. So in the state vaping cases, Superior Court Judge Wilkins issued 3 orders, the most recent of which concerned patient access to marijuana vaping accessories. In a nutshell, Judge Wilkins determined that DPH lacked the authority to order the Commission to enforce the emergency regulations. The Commonwealth defendants have appealed all of Judge Wilkins' orders, and the SJC transferred the case on its own initiative. So the appeal is before the SJC at this point. In transferring the case, the SJC anticipated that the order on the plaintiff's intervener's motion as it pertains to medical vaping accessories could be heard as part of the appeal. So we will be clear about the scope of the appeal before the matter is heard by the SJC on December 9th. So the court will most likely make that clear to the members of the public. So in addition to appealing, the Commonwealth defendants have asked the SJC for a stay of Judge Wilkins' orders, which, if granted, could mean that the ban stays in effect until the SJC decides the matter, but again, we do not know that until the SJC acts. In seeking the stay, the Commonwealth defendants reasonably argued that the orders have the potential to create some confusion as to the nature and timing of the ban among members of the public. So while the Commission is not a party to this appeal and our role is limited, we've been monitoring the proceedings very closely. So I'm happy to take any questions on the recent order by Judge Wilkins, but essentially Judge Wilkins determined that the Department acted in excess of its authority.
Thank you. Other questions for General Counsel? Thank you very much. Appreciate that. My perspective, and I hope to share with the other commissioners, while there's a possibility of many different outcomes here, including a stay being granted or not granted, the appeal succeeding or not succeeding, I believe that the Commission needs to have a plan in case the stay is not granted. And so I believe while any plan we come up with obviously could change based upon the decisions that you just talked about, I think we still need to discuss the plan today in case the stay is not granted. And again, we're not taking a position on if it will be granted or if it will not be or whether it should be. It's just literally we'll take guidance from whatever decisions are made with respect to the request for a stay. That being said, if there are no questions for the General Counsel, then I would like to turn it over to the Executive Director and ask Mr. Collins to talk about his thoughts on a path forward given his conversations with both staff and other commissioners. Mr. Collins.
Thank you, Mr. Chairman. So as was indicated, this is an evolving...
Sean, I think you probably need to be a little closer.
I'm speaking into the microphone. People can hear me?
Can you hear him in the back?
Wonderful.
Great, thank you.
So as was indicated, this is an evolving legal matter as well, I think importantly, as an evolving policy matter and scientific matter. And that's something I think we need to weigh and consider in the context of any response that may come from the Commission. And so as we monitor the proceedings, and also important, the Commission itself is not party to these proceedings.
Correct.
We have thought through a variety of options that may be considered in the event that a stay were not to be granted and that this would not be extended and further deliberated by the Supreme Judicial Court. So one of the things that I think is included in any decision we make or any relative to any licensee or any product is the ability, based on our existing regulations, to intervene in the event there's a public health or public safety consideration. So if the ban were to be lifted as it pertains to medical marijuana patients and products, we do have tools at our disposal that we could deploy through administrative action, which would ultimately, the myriad of options include administrative hold, quarantine, or the removal of product process. Those are things I think we have to consider in the event that the stay were to be lifted as it pertains to medical marijuana patients and products.
Not if the stay were to be lifted, if the ban was to be
I'm sorry,
lifted.
if the ban were to be lifted and the stay were not granted. And also, regardless of the proceedings and how they ultimately unfold, that authority and that process exists and will maintain as well. So as this evolves, I think that's something for the commission to keep in mind as well as the public, is that this is something, an authority that is used by the commission in a variety of contexts. So that is not exclusive to this matter.
Right.
So therefore, if the stay were to not be granted and November 12th at 12:01, Judge Wilkins' order were to take effect, that is something I think as an administrative action that we would have to consider. And in doing so with again, the public health, public safety implications, given again the scientific concerns, as well as the quality concerns around the cartridges, the vape oil cartridges today. And the things that we would take into account in taking such an action would be these cartridges have been sitting on shelves for a number of months now, and the quality of those as far as the substance within them, but also the plastic cartridges and any potential for leaching that may have occurred, and the lack of a recent test relative to the quality of those. Similarly, is the jurisdictions across the country, as well as the federal agencies, CDC, FDA, continue to evaluate these cases and the circumstances around them, because at this point, no one culprit, so to speak, has been identified as being producing these adverse health effects. Similarly, if there were to be an administrative action relative, again, to administrative hold, quarantine, or removal of product, the commission could also consider regulations, emergency regulations or normal course or routine regulations around. We do have, and to be clear, the commission today has promulgated regulations relative to product manufacturing, which includes vaporized products. If there were an intention to strengthen, bolster, add to those, that would provide an opportunity for the commission to consider it in due course, in a normal course, including the normal promulgation process, as well as the opportunity for public hearing and public comment. So at this point, if next week 12:01 were to occur, it would be my intention to consider and deploy the potential for an administrative action being a quarantine of vape oil cartridges. Okay. A distinction, I say that specifically because also included within the ban, in the context of the ban, is flower vaporizing, as well as metered dose inhalers. Those, based on the science and the discussions nationally, do not appear to be implicated by the adverse, or do not appear to be implicated in the context of the adverse health effects that are arising. So it would be a surgical, narrow approach, but one that I think we would be well within our existing authority to consider, as well as justified in doing so.
So I'm going to, unfortunately, nail you down a little bit here, if I could. Could you be precise with respect, you've used the word consider and enforce with respect to administrative action, specifically a quarantine. So I'm going to ask you for three things, if I could. One is, could you be precise in the language in terms of consider versus action? Two, just can you be explicit again? I think we all got about it. I just want to make sure there's no misunderstanding. If you were to take an administrative action with respect to quarantining, what would it cover and what would it not cover? And then third, I would appreciate you explaining your rationale for using quarantine versus other administrative actions that you'd have available to you. Are those fair questions?
Mr. Chair?
Yes.
I would like to, I guess, given the context of what the executive director just said, and that I think there are a lot of there's still a lot that we don't know here. I think that it may be a little bit premature to be asking for specifics about what an action might look like. And I guess I don't want to put us in a position where we are suggesting that we're going to, or that the executive director is going to be pinned to one particular action when we might have a
No, I don't disagree with you, Commissioner McBride, at all. I think that's fair. I wanted to clarify. Let me try to be careful here. I'm not asking for anything additional from the executive director. I just want him to clarify the comments he made to this point. Is that fair? Or if you're not comfortable, then if you prefer to hold off until we have a commission discussion, I'm happy with that. But I just want to make sure I understood what you just said.
Sure. So
So it's only clarification, not further.
So I guess to navigate between that a bit, which is, I laid out the number of different options that would be at our disposal as a commission globally, not as the policymakers, 5 commissioners,
Right.
but as a commission, as an entity. To Commissioner McBride's point, as I indicated at the outset, this is a rapidly evolving dynamic, both from a legal standpoint as well as a policy, scientific, and medical standpoint as well. So the precision of the action what I mentioned is the potential to be surgical in our approach. So I did mention, for instance, at this point, vaporized flower does not appear to be implicated by any of the national discussions. So at this, the concern that I would have would not be related to those devices or that product or that delivery method. At the same time, the concern I have around the oil-based cartridges is the lack of, at this point, I'm not suggesting by any means that they're safe, but I'm also not suggesting that legal product has been implicated as a global. It's been identified as a potential source, and I want to be clear about that, which means at this point the uncertainty around it is concerning. So we would want to make sure that there are precautions that are taken. The way we would go about doing that is the potential for a quarantine of that inventory, which would allow for the commission to test where appropriate and where necessary, but also allow for licensees to identify their inventory and identify the products or the additives or any sort of ingredients that may be included, to give us that opportunity to do that, to ensure the public that we know what's in these products. So that my intention would be to pursue the potential for a quarantine. But to Commissioner McBride's point, the precision of what that would entail needs to be, I think, more fully vetted. But it would be my intention to pursue that and vet that so as to react, I think, in a timely manner. Again, this assumes and it assumes just from a planning standpoint that the stay would not be granted, the ban would be
I understand. Everything we're doing is.
Which is a big assumption.
That's a big assumption, and we'll obviously adjust as appropriate as we get more information and as this case proceeds. But thank you. I appreciate the clarification. I think it is now appropriate for the commission to start commenting and weighing in. So, Commissioner Title, looks like you had your hand raised, even though we're not in school anymore.
I actually just wanted to make a point on that previous discussion that we just had. So I was about to say exactly what Commissioner McBride just said in terms of those questions being premature, but I also just want to call attention for context to the quarantine process, which was developed by staff and commissioners and promulgated. And that process reads, pursuant to its authority, I'm reading excerpts, a quarantine order may be imposed by the commission to immediately quarantine or otherwise restrict the sale or use of marijuana or marijuana products or MIPS if based on complaints, inspections, affidavits, or other credible evidence. And so I do think that it's perfectly appropriate, as Mr. Collins just laid out, that if the ban was lifted, a quarantine should be considered based on those items. And so if we don't have those items and they haven't been considered, to discuss an action without considering those items would be premature.
Commissioner McBride?
I'd like to make a motion that I think might provide us with context to maybe engage in this conversation.
Let's consider that and then go ahead.
Okay. So I'm going to pass this out.
Yeah, please, thank you. Yeah.
So I move that the commission begin the process to promulgate adult use and medical regulations relative to the vaporization of marijuana products, including but not limited to extracts, concentrates, and any marijuana accessories or devices used for the consumption of vaporized marijuana products. Move further that the scope of any regulations considered by the commission shall be limited to 1, ingredients, 2, labeling, 3, testing, 4, sourcing, and 5, storage of marijuana products intended for vaporization, and further, that the commission affirms the authority of the executive director granted by Chapter 94G, 935 CMR 500, and 935 CMR 501 to take administrative action to ensure the safe sale of marijuana products in the Commonwealth pursuant to those regulations. So, following up on Commissioner Title's comments, this is affirming what the authority we've already granted. and enabling the executive director to take, pursuant to our regulations, appropriate actions, but providing for the flexibility to see what happens in the next few days relative to litigation. And also, I think puts us in a posture to begin a process that I think we probably would be heading towards anyway, as we are taking into consideration what is going on around us with regard to regulations. So I would put this out there for discussion, but I think that this puts us in a posture to be responsive, but also begin a process that we're moving towards, in my mind anyway.
Thank you very much, Commissioner McBride. What I'd like to do, before we actually ask for a motion in a second and take a vote, is let's discuss this and kind of see where we are. So let me ask for comments on either what Commissioner McBride has suggested or others. Commissioner Flanagan?
Mr. Chairman, thank you. I think that we all know, and I appreciate the work that's been done by our legal counsel, by the executive director, and I appreciate the work that's been done by the staff. We have a lot of work in front of us licensing, let alone adding the issue of vaping to it, and the fluidity of what's going on in the court system. That I think as a commission, we need to recognize that there's a lot of activity going on outside these walls. And that activity, with it will come decisions or consequences, and that could have an effect on the decisions that we make. The truth is that we don't have all the answers. And while I know that I have been approached by people, and people have reached out to me saying, I know what's best, and I know what's best, the reality is that as 5 commissioners, we took an oath to do what's best for the Commonwealth and for the people in the Commonwealth. And I think from my opinion, it's important that we support the motion that was made, that is going to be made by Commissioner McBride, so that we do what we do best. And there's no pun intended. We take a thoughtful, deliberative approach to this process. We hear from all sides. If we engage in this regulatory process, there will be public comment. There will be public hearings. The general public will have their opportunity to talk to us as commissioners. And you really don't get that opportunity in the court system. There's a court case going on. If there's a decision in a couple of days, that could negate what the decision that we make today. The truth of the matter is there is a health crisis going on in the United States. Choose to agree with it, choose to disagree with it, criticize it, embrace it. The reality is that 3 people in Massachusetts have died. There are many people across the state that are sick. And the reality is that even the CDC doesn't have all the answers yet. And so for us to be able to take this deliberative approach, I think really is something that is best for the Commonwealth. I think it's best for the patients that we serve. I think it's also best for the consumers that choose to buy the products that we have in our dispensaries. So I appreciate the motion that Commissioner McBride brings forward, because I think it shows that once again the Cannabis Control Commission is taking the approach we've always taken, which is to be very thoughtful and very deliberative, and to make sure that there's not just 5 people making this decision, but there's people that can be heard from the Berkshires to the Cape. So I appreciate the work that has been done to put this together, and I'll support this motion.
Thank you, Commissioner Flanagan. Are there other comments before we ask for a formal motion? Go ahead, Commissioner Doyle.
Thank you very much to Commissioner McBride for the thought that went into this motion. I think it is definitely a step in the right direction. With regard to the second clause talking about the scope of our regulations, the one thing that I think may not be covered in this list, which is very comprehensive, is the chemical process of vaping. And we may discover that the application of heat to the ingredients is at issue, at least in part, as the investigation goes on. And I'd just like to make sure that we have the opportunity to address that if need be. And so I would just ask if we could add that as a consideration. And I was trying to come up with some wording, but if we could add as an additional in the list, a number 6 regarding the chemical process of vaping as something we could look into as part of our regulations.
Okay, go ahead,
Thank you.
Commissioner Tuttle.
I support this motion, and I thank you to Commissioner McBride for the thoughtful motion. I do have a question. Is the motion to begin the process of promulgating emergency okay.
So I think it wasn't drafted intentionally to allow for there to be flexibility. So yeah, I think that, like a lot of things, I don't have an answer to that. I envision this as a normal, quote unquote, normal regulatory process. But depending on, what develops, and as we have all seen, it's sort of developing in a real-time way. If we need to be responsive in a different way, then this gives us the ability to at least start to move forward with having the policy discussions with staff and identifying what in the regulations we might want to see relative to these categories. And then if we need to, do something that's more expedited, we're in a position where we can do that.
I appreciate that. I agree with that. And of course, if there's more information that comes to light, we always have the authority to promulgate emergency regulations. I have a additional suggestion to Commissioner Doyle's suggestion.
Go ahead.
Commissioner Doyle, you said chemical process. Yeah. What do you think about manufacturing process as well?
Yeah, I have no objection to that. We obviously need to give ourselves some room here because we may find out that things are at issue that we're not aware of at the moment.
Thank you.
Okay. Then, unless there are other comments from the commissioners, I actually have some things that I'd like to raise and ask about. So first of all, let me just join in with everybody in thanking Commissioner McBride for her leadership on drafting this. I think it's well, as always, incredibly well thought out and executed. So thank you, Commissioner McBride. I have, I guess, one concern and one question. So let me start with the question. I understand that we don't feel comfortable today deciding on the nature or the timing of the regulatory process that you've suggested in this motion, but I feel a sense of urgency to determine that and to start that process, whether it be an emergency regulatory process or a normal but hopefully compressed regulatory process. Can we put in here, or have you thought about when we need, I would like just to specify when we are going to make a decision, or at least some time frame for making that decision, because I really feel a sense of urgency to get that regulatory process, regardless of what administrative action we take, if any, to start the regulatory process, presuming, again, that the stay is not granted. Do you have any thoughts on that, Commissioner McBride?
I don't. I would defer to general counsel and to legal counsel, I think, on this, except with the caveat being that we are somewhat tied just by the rules of 30A.
No, I understand that we can only compress it to a certain point. I appreciate that. I was asking less about what decision we'll make and what the process will look like, as opposed to when we will make a decision about what regulatory process we will follow and what time frame. And I just would like to put something in place that says we'll make a decision around this within a certain time frame. And I don't know if you've thought about that, and after you, I'm going to ask the same question to the executive director, but go ahead first, please.
Well, I think it's kind of hearkening back to the conversation or the comments that Commissioner Title made, right? That I think it's a little bit difficult because we don't know how this is going to evolve necessarily, and there may be a set of circumstances that would push us in the direction of us having, an emergency meeting, or I think that those circumstances are yet to be determined. Understanding the nature of what we are dealing with, and that we want to deal with this expeditiously, but also appreciating, I think, what the executive director has stated, and I think that we all understand that there's information that we as a commission need to collect and hear from people about. I'm sort of loath to say, in my mind, it's going to be on this date. I think that we start to develop as individual commissioners in conjunction with staff. I have sort of my list of things that I would like to see, and I would encourage people to start thinking about that and sharing that, and begin the active process of putting pieces together, putting language together, so that when we need to move on this, that we are able to move on it, but with the idea being that if we want to set a sort of a time frame for all of us should have those thoughts, to staff to put together a draft by a certain date. I mean, that makes sense so that we can sort of move forward, as we did in the last, our recently concluded regulatory process.
Yeah.
I don't think we should be necessarily doing this, 6 months from now.
No, I agree with that, but I don't think, maybe I just didn't articulate my question. I agree with everything you just said. What I'm saying is there's some ambiguity about what this regulatory process is going to look like, whether it's going to be emergency, and I think that ambiguity is appropriate given all the uncertainty. What I was asking, when are we willing to commit to make a decision about the regulatory process? Not the content of it, but the process we're going to follow. When will we be in a position to make the decision so that we can get started on the appropriate process? I just don't want to leave, my preference would not be to leave here today and say, sometime in the future, unspecified, we're going to make a decision about a regulatory process. I would rather say, if we can't do it today, and I completely recognize that it's probably inappropriate or impossible to do it today, given the ambiguity, when will we make a decision about the regulatory process? Not the content, but the process. I would like to have some agreement on a time frame on that decision. And I don't know,
Mr. Chairman.
can I go ahead, Commissioner?
Are you
Lemkin.
suggesting a time frame?
I
I mean,
I would
you're
like-
asking for a time frame, but I mean, I'm kind of wondering if,
I want a time frame for this, again, please, let me just be unambiguous to the extent I can. I'm not asking for a time frame for a regulatory process. I'm asking for a time frame to make a decision about a regulatory process. And I think that's appropriate. I don't want to leave this ambiguous about when are we going to decide how we're going to proceed here. I'm not trying to force a decision about how we're going to proceed. I'm trying to force a decision about when we're going to decide how to proceed.
but then that goes back to my question, are you suggesting a time frame?
I'm suggesting, yes, that if the stay is not lifted on the 2nd, then I would like to ask the Executive Director and the Chief of Staff to find a time for us to meet in a session, a public session, as quickly as possible after Tuesday, to make a decision, again, not about the regulations, but the regulatory process we're going to follow. Because I think we need to be, again, this whole conversation today can become completely moot shortly, depending on court decisions. But if the stay is not granted, I want us to be very clear about how we're going to proceed, not just with respect to the administrative action, but with respect to the regulatory process. And since we can't, at this point, agree, or I think it's premature for us to try to agree on what that regulatory process is, I want us to put in place a timeline to have the conversation to agree on what regulatory process we're going to follow and what the timeline for that regulatory process is. So am I making myself clear, or can I have comments or thoughts on what I'm saying? Because it's only half of what I want to talk about, so let's go ahead, Commissioner Doyle.
Mr. Chairman, I have a question for General Counsel.
Shape, go ahead.
General Counsel, could you refresh us, obviously there is a issue with the stay, but following that being resolved, what are the next steps could you refresh us on what the next steps are at the Supreme Judicial Court following the ruling on the stay?
Yeah, so currently, most of what Judge Wilkins decided is before the SJC as part of the appeal. The court anticipated that there would be this recent decision on the plaintiff interveners, essentially the medical patient's motion, and anticipated that that could be considered as part of the appeal on the oral argument on December 9th. I think it's likely that everything will be consolidated and heard by the court on December 9th. That being said, the court will obviously need time to render its decision. They will understand that it's an emergency situation of sorts, or they may understand that. They'll probably have to decide that as well. So that will impact the timing of their decision. In terms of this motion for a stay, I'm sure that the court understands that in Judge Wilkins' most recent order on November 12th was significant. So I can't say for sure, but I would anticipate that the SJC would take action potentially by the end of this week to clarify the situation. That is whether there is going to be a stay or not. It's also possible that the court, single justice of the court, will hold an evidentiary hearing on the issue of the stay. And again, that's completely at the court's discretion. Is that helpful?
Yes, thank you.
Do you have now a follow-up comment based upon that?
I'm just highlighting the fact that there is a significant legal uncertainty here, and that as a result of that, I would just urge caution in trying to define a specific time period now, because we may have to change that time period in reaction to a ruling from the Supreme Judicial Court.
Once again, I guess it's not clear to me why this is not coming forward. I am not asking for a time frame on a regulatory process. I'm asking for a time frame to make a decision about how to proceed with respect to the regulatory process, and I'm perfectly happy to consider a time frame that says when the Supreme Court has decided on this, if that's what we want to say. I just don't want, I think we would be shirking our responsibility to leave it open-ended that at some point in the future, unspecified, we're going to talk about a regulatory process. And it could, so options in my mind could be, if the stay is not granted, then we convene as quickly as possible, given everybody's schedule, to talk about the regulatory process. It could be that we say, when the Supreme Court has ruled on the appeal, we will convene. I just think we need to provide that level of specificity. I understand there's uncertainty, but I don't feel, as I said, that we would be fulfilling our responsibilities if we just said at some point in the future we're going to talk about a regulatory process. Commissioner Title.
Thank you. So my thought on a timeline is that there are a couple items of additional information that I need, both to discuss the decision, but also to discuss a timeline. Is it okay if I say what those
Please.
are? Okay, so the first is that in Judge Wilkinson's ruling, it's noted that 94I Section 7 may prohibit a ban on medical marijuana vaping products. And given that statement, I would like a legal opinion on that. So I'm wondering if, A, is that possible, and B, if so, what would be the appropriate time frame?
Okay, and before she answers that, I think it's very important, but you have other,
Yes, one other one.
so why don't you do that, and then we'll go back to the General Counsel.
The other information that I need is implicit in another sentence in the ruling, which says 1 week is likely enough time to consider emergency regulations, since the CCC already has experience as the agency implementing the emergency regulations for the marijuana industry and has the benefit of all the work done by DPH to date. And there's an implication there that we have access to that information. If we are going to be considering a quarantine, and it sounds like from the executive director's comments that we are, the relevant question is, are any of those products that we're considering quarantining, i.e. those products that have been sold by businesses as medical products, are they linked to any illnesses? And that information surely exists, even if it's preliminary. And so I would want to make a formal request for that information before we have this discussion.
Before we have which discussion? On the motion?
Before we have the discussion to promulgate regulations pursuant to the motion on the table.
So let's go back. Let's take them one at a time if we could. So, General Counsel, do you have a comment on Commissioner Title's question about rendering a legal opinion?
Sure. Basically, in Judge Wilkins' order, he determined, as I said before, that DPH lacked the authority to order the commission to enforce the ban. In part, the judge was relying on Section 94I, Section 7. In other words, whether the commission, and that's important here, has the authority to enact basically a regulation that is more restrictive than what DPH enacted.
And what had in place as of July
when it
1st.
had the program.
Yeah.
This will be a novel issue of law before the SJC. There are arguments, good arguments for and against this interpretation. As the Commonwealth defendants indicated in their motion for a stay, there is an argument that the Department of Public Health in promulgating the emergency regulations or initiating the emergency regulations wasn't bound by 94I. The Commonwealth defendants also argue that they had other sources of authority. They still maintain that the commissioner's original order is valid. So this issue will be potentially before the court. Now, the court will have some discretion as to whether it reaches this issue. The court, for example, might just reach the issue of whether the commissioner had the authority to promulgate the order and whether the department had the authority to promulgate the regs and look at that more narrowly. So the court could also exercise its discretion not to reach the question of 94I. Is that,
Yes.
So how does that affect your thinking about the time frame then of deciding, again, not the time frame of developing regulations, but the time frame of deciding how we will proceed in a regulatory process? Does that affect your thinking?
It does. So, so first, if we make that request for the information about whether the products we're talking about are...
You're talking about a formal request to the
illnesses.
Department of Public Health?
Yes, I am talking about a formal request to the Department of Public Health. Then we need to give sufficient time to reply with that information, one. And two, if the information suggests that these products are implicated, then I assume we would want to have an emergency meeting immediately. If not, then my suggestion would be that we discuss this at our next scheduled meeting.
I just want to make sure I'm understanding. I'm not arguing or disagreeing or debating. I'm just trying to understand. When you said you were concerned about lacking two pieces of information, are you talking about with respect to voting on this motion today until
No.
you have that? You're just talking about the start of the regulatory process?
Yes.
Great, thank you. Okay. Are there other comments?
What?
Go ahead, Commissioner. Let me,
No, go ahead.
Commissioner Flanagan.
Well, my question is that we're having this discussion. Are we ultimately taking a vote on whether to make this time frame? Because if not, then I don't think we should make a time frame. I think it's disingenuous to create a time frame given the fluid nature of what's going on in the courts, and then to have people come back to us and say, well, you said this was going to be hopefully your time frame. I think we have to go along with part of the process that's playing out, again, outside these walls. And the fact of the matter is that all five of us, and I don't want to speak for the five of us, see this as important. So we are all taking whatever actions we need to within our different purview to ensure that this is addressed. And if Commissioner Title is looking for information from the courts or from DPH or whomever, we don't know how long it's going to take for her to get that back. And if that's something that she needs to have, then we need to agree with that. And I think any of us that need information have the ability to ask for that and would expect the same respect. So I don't think the time frame is as important as the activity that's going on. And we can go round and round, and unless there's going to be a motion for us to take an actual vote on whether or not we're going to have the time frame, I think we let the staff do their jobs, we all do what we have to do, and we continue to push forward. As, like I said, there's a crisis going on, so no one's going to sit on their hands, whether it goes through the Thanksgiving holiday or the Christmas holiday or the New Year holiday. We're all going to have to keep working at this alongside what's going on in the court system. So if there's not a vote, I'm saying publicly, I don't think we need a timeline. I think we've shown in the history since we've been here in 2017 that we act on things as needed, and we would continue to do that.
Commissioner McBride?
First, I would just agree with what Commissioner Flanagan just said, that I get nervous about pinning us to a timeline when there's still a lot that's developing, which is why I've sort of been hemming a little bit. Respecting Commissioner Title's comments, I agree that information is absolutely necessary. But I also want to make it clear that information from DPH isn't going to be the only evidence, right? And so I do want to clarify that the executive director needs to develop what he believes to be the basis for any action that he's going to be taking, and that it's not just going to be sort of narrow to, that information, that he should feel empowered to collect whatever information and reflect on that information with staff to make a decision. So.
If I didn't make that clear, I apologize. I absolutely agree.
Okay. So it's clear that I am not going to carry the day here. I vehemently disagree with where we are right now, but I will support the majority of the commission on this. I will say that I am not asking for necessarily a specific date. I am asking if there are conditions that include finalization of this litigation, whether it's a stay or whether it's an appeal, receiving the information that you feel is necessary, saying that as soon as we have that, we will act. Maybe that's not necessary, but I just feel, and I'll stop after this, I feel just saying, well, we'll get to it. It just is inappropriate. And I respect Commissioner Flanagan's point. We have always done the right thing, and we always have taken the appropriate action, so perhaps we don't need this. But I'm personally uncomfortable with where we are, but I support where we are. That being said, I'm now going to make it even more difficult because the second concern I have is saying that if the stay is not granted, at 12:01 a.m. the governor's order expires or is lifted, we might consider doing something, or we will consider doing something. I am not comfortable with that. I am not comfortable saying, we'll see. I do believe we have to, and this is, I'm speaking personally, obviously, we have to say if the stay is not lifted, or if the stay is not granted, this is the action we will take. Now, I would like to say we will start a regulatory process, but I just found out that I'm not going to get support on that. But with respect to administrative action, I'm incredibly uncomfortable saying that if the stay is lifted, we'll consider taking administrative action. I believe that is shirking our responsibilities to an extreme. So I'd like to hear comments on that, but in case it's not obvious, I feel really strongly on this topic. So feel free to disagree with me. It hasn't stopped anybody up to this point. Commissioner Doyle.
I don't think anyone's shirking anything. I think that
Let me speak for myself. Okay, I apologize. I certainly did not mean to imply that anybody's shirking there. I would feel that I was shirking my responsibilities. Let me put it that way.
I am just going to rise in defense of the fact that I know we've all been concerned and looking at this as the developments have unfolded, and I think it is something that requires a careful approach, which is why I get nervous committing absolutely to something in a meeting where we may not have sufficient information to act yet. So that is the source of my discomfort, where we have the ability to take the action as described by the executive director, or more appropriately, he has the ability, doesn't need the public meeting to do what we have discussed, and has expressed a willingness and intent to do so thoughtfully. I am comfortable and have faith in his ability to execute the policies that we have expressed over the past 2+ years to ensure the safety of the patients and the consumers. So that's I'm just telling you where I'm coming
No, I
from.
appreciate that.
Yeah.
I think that's what this conversation is for, is so people can express their opinion on that. Are there other comments? Commissioner Flanagan?
I agree with Commissioner Doyle. I think that I have faith in the actions that would be taken by the executive director. And again, it's hard to pinpoint without all the information in front of us. And as is stated multiple times in 2 years, I'm not a lawyer, so I'm not sitting in the courtroom. I think it's incumbent upon us to be a little flexible in this and use the tools that we have and embrace the tools that we have to get to an end result. So I'd be a little hesitant to say what we're going to do if this,
I'm sorry,
then that.
excuse me. I apologize for interrupting. Go, keep going.
No, I mean, I just think that, I want to hear the court, and I want to know what's going to happen, and, to say if this, then that, I think just gets dicey.
What information are we going to get between now and Tuesday at 12:01, other than if there is a ruling on the stay? What information that we do not have right now are we going to have other than the court decision?
I think if I can,
Yeah, please. No, that was a question, so
yeah.
you're more than welcome to provide an answer.
I think that the first thing that popped into my head when you asked the question was, well, we don't know. And the CDC has been very good about every week, providing updates about what is going on, but we don't know the update around the corner. And even if it's not the regular update, if they have some sort of breakthrough, that could happen between then and now. So again, I would be concerned about putting in place some sort of mandate direction to the executive director that may make him feel that he is confined in his ability to react to a situation that is so fluid. So I think if that better expresses my.
No, I think I understand your point of view. Commissioner Title?
I couldn't really say it any better than Commissioner Doyle just said it. So let me just endorse that. But let me also add that the executive director has had the power to quarantine or recall products this entire time.
Yes.
We did have a discussion about our concerns back in early September, laid out a plan that I think was fully appropriate. And I have had, not only do I have full faith and confidence now, I've had full faith and confidence this entire time that if there was any evidence that would warrant that kind of action, and the evidence changes by the day, that appropriate action will be taken.
Thank you. So, I feel forced to clarify, what I would have thought would have been obvious, but I have complete confidence in the executive director. My comments have nothing to do with any lack of confidence in the executive director. That being said, I feel a personal accountability. I'm speaking for myself, and I'm not being critical of any other commissioner. I'm speaking explicitly for myself. I feel an accountability to use the greatest amount of caution we can possibly use, given the lack of information here. And I don't feel comfortable just saying, we'll see what happens. And see what, I just feel in my job, I need to ensure that we are doing everything we possibly can to be cautious, because people's lives are at stake here. And I don't feel, without any implications whatsoever with respect to the executive director, because I have complete confidence in him, I don't feel comfortable just saying, okay, make a decision on Tuesday. I don't feel comfortable doing that. And please, Mr. Executive Director, understand that has nothing to do with my lack of confidence. I hope you don't interpret it that way. Go ahead.
So I really have to take issue with the characterization that anyone is saying, we'll see what happens. No one is saying that. And if you feel that a particular action is warranted, could you raise that specific action rather than just the general idea of taking action?
I heard the executive director in his remarks say this was an administrative action that he would consider. I think that was your language, consider, with respect to oils, but exempt. Could you actually, if you wouldn't mind repeating that, Mr. Executive Director?
I can. I also, though, want to, I think, clarify something, which is embedded within every action that I consider as Executive Director, and I think the Commission has incorporated into your existing regulations, paramount is public health and safety.
Yes.
And so at no point in making any decision is that not a factor, not a consideration.
I appreciate that.
With that in mind, though, to the various commissioners' points, this is something we have been monitoring, will continue to monitor, will monitor beyond the consideration of any stay or any judicial action. But because it's evolving, what I'm saying is, and I guess to your question, Mr. Chairman, what I will commit to is that as this evolves, we will pursue and seek any evidence that would rise to monitor that public health scenario or situation. If at any time there is a threat to public health or safety, I will take immediate action, as I have and as I will in the future. And that rises to the level of the various options: administrative hold, quarantine, product removal, but also, and it's specific to licensees and individual circumstances, but globally, industry-wide, medical or adult use regardless. So I think hopefully to bring comfort to your concern and question is, at this point, we are working to develop that evidence. And also to Commissioner Title's point, seeking that evidence where it may be, and if we may not have access to it. With that in mind, which is if the stay were to be lifted, I would have every intention of deploying any tool that we have to ensure that product that may not be safe for consumers or for patients does not reach the marketplace and does not reach any patient or consumer. So that includes, and I think at this point it is leaning toward the potential for a quarantine. But I say consider with, I guess at this point, every intention of pursuing that with vigor and I think any resource we have at our disposal. So I don't know if there's a more impassioned way to relay that to you, but
I appreciate what you
by
said.
no means is there a responsibility
I'm
to be
gonna,
shirked.
I'm gonna go back to asking for a motion. I've made my point. I completely respect and am comforted by what you said. So I've made my points. Commissioner McBride, would you care to make a formal motion, including the suggested changes by Commissioners Doyle and Tittle, unless there are further comments or questions?
Mr. Chairman,
Yes.
I just have one last thing to say. I think that, given the discussion that we're having here and giving the multitude of opinions and the places that we come from, the reality is that you're right, lives are at stake here. And it's an uncomfortable place to be, to have to make decisions when you know lives are at stake. And, you know, I've been through a health crisis here in the Commonwealth before. I've had to make decisions, you know, back in 2013 and 2014 when we had to address another crisis. And it's very an uncomfortable place to be, but there's an opportunity to rise to the occasion and to come out on the other side knowing that our full intent is to protect the public health and public safety of the Commonwealth and the people that live here. This is, I mean, I go to sleep thinking about this. I wake up thinking about this. I have people stop me every single place that I go to talk to me about whether they're for it or against it. Emotions are running high with this. People are very passionate about this, whether they're patients or consumers or caregivers or family members. But the reality is that we want to get it right, and I don't know if we have many opportunities to do that. So we've got to take the time to do it right in the first place. And I appreciate the commitment by the executive director to say that he is going to take action when he absolutely can and to gather the data, because I think that the data is what we need. You look through our Chapter 55, our enabling statute, you look through our regulations, scientifically proven, scientifically based, it's been there since the beginning. And unfortunately, we got here for whatever reason we got here. But the reality is that we now have to wade through this to get past the initial crisis part and to get to the other side. So I think that as a team, the Cannabis Control Commission is going to do well, 5 of us plus all the staff, because we have, and because we have a history of doing that. So I think that while it's uncomfortable, the reality is that we're working, and we're working diligently. And I appreciate the fact that you want to pin down some actions or discussions, but I think we have to also be very aware of the fact that things are just moving quickly.
Thank you. Commissioner McBride, would you care to make your motion again, if you would incorporate the suggestions of Commissioner Doyle and Commissioner Tittle? I'd appreciate it. Are you comfortable doing that?
Yes.
Please go ahead.
Move that the commission begins the process to promulgate adult use and medical regulations relative to the vaporization of marijuana products, including but not limited to extracts, concentrates, and any marijuana accessories or devices used for the consumption of vaporized marijuana products, and move further that the scope of any regulation considered by the commission shall be limited to 1, ingredients, 2, labeling, 3, testing, 4, sourcing, 5, storage of marijuana products intended for vaporization, and 6, manufacturing and consumption processes of marijuana products and marijuana accessories. And further, that the commission affirms the authority of the executive director granted by Chapter 94G, 935 CMR 500, and 935 CMR 501 to take administrative action to ensure the safe sale of marijuana products in the Commonwealth pursuant to those regulations.
Thank you. Can I have a second, please? Let the record show that the motion was made by Commissioner McBride, seconded by Commissioner Doyle. All in favor?
Aye.
Aye. I'll let the record show the commission unanimously approved the motion. Thank you very much. We will take a break now. We'll reconvene at 11:30. Thank you. And silent, please. Thank you. So we are on the third item on our agenda, which is approval of minutes. We have, if I'm correct, 3 sets of minutes to discuss and approve. So let's start with June 25th, 2019 meeting minutes. Can I ask the commission, have you had a chance to review these minutes? Do you have any questions or comments? Commissioner Title?
I apologize, I had caught some typos and not
If
tracked
the-
them yet. Can we do the votes for these subject to ministerial change?
Sure, absolutely.
Thank you.
Any other questions or comments on the minutes from June 25th? So then, can I ask please for a motion to approve the minutes from June 25th, 2019, subject to the ministerial changes that will be required? Can I have a second, please? Let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Aye. Let the record show the commission unanimously approved the minutes from June 25th, 2019. Next are meeting minutes from June 27th, 2019. Can I ask the commission, have you had a chance to review those, and are there any questions or comments? Commissioner Tyler, do you have the same request? Any other questions or comments? Then please could I ask for a motion to approve the minutes for June 27, 2019, subject to ministerial changes suggested by Commissioner Title? Can I have a second, please?
Second.
Let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the commission unanimously approved the minutes from June 27, 2019, subject to ministerial changes. Last set of minutes are from October 10th, 2019. Again, Commissioner Title, you would like the same? Thank you. Then can I ask the commission if they had a chance to review these minutes? Are there any questions or comments? Then can I ask for a motion, please, to approve the minutes from October 10th, 2019, subject to the ministerial changes suggested by Commissioner Title? Can I have a second, please?
Second.
Let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the commission unanimously approved the minutes from October 10th, 2019, subject to ministerial changes. Thank you. I think we're caught up with minutes, so to the legal team, thanks very much for your help in doing this. The next item on the agenda is the Executive Director's Report. Mr. Executive Director.
Thank you, Mr. Chairman.
For some reason, my clicker is less effective than normal. Maybe my clicking technique is less effective than normal. Are you cursing me? There we go. Thank you, Mr. Executive Director. Once again, you proved to be a jack of all trades.
Many responsibilities.
Before we get into the licensing update, are there any new employees
There
to
are.
introduce?
Yes, thank you, Mr. Chairman. So first, I'd like to introduce 2 new employees and also identify a returning employee. So first is Yen Do. Yen has joined the commission as a fiscal specialist. In that role, she's responsible for overseeing and managing our non-tax revenue accounting. In addition, she'll be responsible for ensuring that the commission's revenue accounting adheres to commission policy and regulations as well as state finance law. She joins us most recently from UMass Boston, where she was a financial analyst, and there she assisted in the financial management oversight of the grant office and monitored cash management for federally funded grants within the financial aid office. So Yen Do has joined us as a fiscal specialist.
Welcome. Lawyer or non-lawyer?
She's a non-lawyer.
Well, great to have you on board. Mr. Executive Director.
I'd next like to introduce 2 lawyers. Seriously, actually. First is Rebecca Lopez. Rebecca joins us as an associate enforcement counsel. In that role, she's responsible for assisting our investigations and enforcement unit regarding legal matters with licensing, inspections, investigations, and suitability issues. She comes to us most recently from Community Legal Aid based in Springfield, where she was a staff attorney in the elder law unit. There, she advised and represented clients in matters related to accessing or maintaining government benefits. Prior to that role, she was a staff attorney with the Massachusetts Fair Housing Center in Holyoke. So please join me in welcoming Rebecca to the
Rebecca,
stand.
welcome. Notwithstanding the fact that you are an attorney, you're very welcome and delighted to have you part of the commission. Mr.
Similarly,
Executive Director.
I'd also like to reintroduce or identify that Andrew Carter has pivoted into the role of an associate enforcement counsel. So he has broadened his horizons here in the commission and joins Rebecca as an associate enforcement counsel. So that staff adjustment or change has been made.
Welcome back, Andrew. Is this our first returning employee?
It is, yeah.
I think hopefully that's a continuing precedent. But welcome back. Well, but if they do, we want them. But
Why would they come back?
well, if they leave, I am not suggesting we try to get them to leave, but if they do leave, it's nice to have them come back.
Moving along,
Mr. Executive Director, any job postings?
at this point, no, we have a number of roles. We can, as you can see, we continue to fill roles periodically, and all of that is, we have a number of postings that have closed. We're actively interviewing to bolster each of our different departments. So we are an agency that continues to grow, and we're excited about that, and also excited about welcoming folks with a diverse skill set and diverse backgrounds to further inform a lot of our work, as well as to assist the commission in their policy-making roles. So.
Okay, thank you very much. Anything else before we move into your licensing update? Go ahead, then.
So this is the typical data as presented and extracted from the Mass Cannabis Industry Portal. You'll see here there's a total of 395 applications that have submitted all 4 packets and are therefore considered or are pending review, and the breakdown obviously in the right-hand column there. Next is a breakdown of those 395 of the total, the total portal as a whole. Again, the 395 that are pending, 389 have been withdrawn, 3,510 are incomplete or therefore not have yet submitted 4 packets. To date, 4 applications have been denied and 207 considered and approved.
Thank you.
Next is a breakdown of those applications that have been, licenses that have been approved by their category. Again, see that total is 207. The majority, or 80, are retail applications or licenses, 64 cultivation, and 53 product manufacturing.
Thanks. Any questions before we go on?
Of those 287, this is a status as far as where they are in our licensing process. Again, you'll see that there's 8 that have been provisionally approved, 108 provisional licenses. The distinction there is that provisionally approved is not yet paid their license fee. 14 final licenses and 77 entities have commenced their operations. This next slide indicates their status as far as general applicant, RMD, economic empowerment, priority applicant, or expedited review. The 606 applications represent 319 separate entities. I should also indicate the expedited review is a fluid number at this point, as folks are identified continuously for that status. Related to that is notice that will be sent to all applicants regarding the ability to identify as being eligible for expedited review. So I expect that number to continue to rise.
Great. Thank you.
The next slide is a bit of a demographic or disadvantaged business enterprise statistics. This is information that is supplied and submitted by the applicant. You'll see that of the 606 total applications, there's 503, the majority, 83%, have not identified as a DBE business. This is, again, related to the expedited review process, a number that will be modified or fluid as well, but I think also allow us to be a lot more precise and accurate with that data.
Great. Thank you. Commissioner Tuttle.
I just wanted to confirm this because I've said it in public a few times since the last meeting. If a business would like to be certified as one of those categories, there's no reason for them to wait to pursue it, right? To start the training, et cetera.
That's absolutely the case. Yes.
Thank you.
Any other questions?
This next slide indicates a bit of or peels the curtain back a little bit on our review, which is that 156 have been submitted. Again, the 4 packets are awaiting initial review. 156 have been reopened, requiring additional information. 63 await additional third-party responses. As a reminder, those third-party responses include a background check as well as municipal notice. 20 are before you for consideration today, and 211 have been considered by the Commission.
Thank you. Questions?
The next 2 slides indicate a bit of a geographic breakdown across the Commonwealth. The first one here is total applications pending and where they hail from or where they intend to be located across the Commonwealth by county. Again, this is all applications. This next slide is specific to retail applications, and again, the breakdown is by county.
Thank you.
This next slide is a indication of a total universe as far as by license type where folks are at in the process. Again, it's busy, but I think it's informative as far as what is pending in the queue, again, regarding license type and where they are in their process as far as pending or actually having commenced their operations. The next few slides are relative to agents. You'll see there's 9,661 total agent applications. However, that universe is 6,715 are actually active. Of our workload, there's 234 that are either pending as establishment agents or as laboratory agents. Of that group, there's 102 that have not yet been reviewed, 125 that require additional information, 7 awaiting a third-party response. Again, as a reminder, that context is a fingerprint check for laboratory agents. And again, as these are approved administratively on a rolling basis, there are 0 that are awaiting approval at this point.
Great, thank you.
Again, related to the demographics of pending agents, you'll see that the majority, 66.5%, have identified as male. And again, this is a demographic based on gender of agents. This next slide, continuing with demographics, is race or ethnicity. And again, you'll see that 73.4% have identified as white. The next 2 slides really drill down further into our medical use of marijuana program. You'll see there's a total of 162 license applications. And again, the breakdown is on the right-hand side. Similarly, there's licenses. You see there's 96 provisional, 5 final, 54 have commenced their operations, and 10 licenses have expired. This slide indicates data relative to the medical use of marijuana program's agents. Again, you see there's a total of 4,775 active agents. On the right-hand side is additional information relative to certified patients. You'll also see the breakdown here relative to registered certifying physicians at 259, and registered certifying nurse practitioners at 64. We also do certify, have the ability to certify based on statute and regulation, physician assistants. We just don't have any in the
Yeah, I was going to ask about that, but Commissioner Flanagan has a question?
Could you just define the difference between certified patients and certified active patients?
Active patients are actively making purchases during the course of the previous, I think it's 60 days or 30 days.
Okay.
They're in the system, though, there's 67,000 registered issued cards.
Thank you.
Any other questions? Are there any other comments that you wish to make, Mr. Executive Director, or updates prior to moving into the licensing part of our agenda?
Not at this time.
Okay, thank you very much. So we have 4 categories of license actions to cover in the next part of the meeting. We have 1 change of ownership, we have renewals, we have provisionals, and we have finals. So let us start with change of ownership. I believe there is only 1 on the agenda. Mr. Potvin, could you bring us up to speed on Alternative Therapy Groups Incorporated?
Yes, thank you, Mr. Chairman. As you stated, the licensee here, Alternative Therapies Group, is seeking a change of ownership and/or control. The licenses that this will be applied to are 5 adult use licenses and 3 medical licenses. The individual that will be acquiring ownership or control is Michael Young, who will be their Director of Operations. There were no entities disclosed in the application as acquiring ownership or control interests as part of this request. Background checks were conducted on this individual, and no suitability issues were discovered. The individual that is requesting ownership and/or control over the licenses do not appear to have exceeded any ownership or control limits over any particular license type or cultivation canopy. Therefore, Commission staff recommend review and decision on the request for the change of ownership and control, and if approved, request that their approval be subject to the conditions before you.
Thank you very much, Mr. Potvin. Are there questions or comments from the Commission? Then can I ask, please, for a motion to approve the staff recommendation or approve the change of ownership subject to the conditions requested by the staff?
So moved.
Can I have a second, please? Second. Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
All opposed? I'm sorry, Commissioner Title, you were aye? Let the record show the Commission unanimously approved the change of ownership for Alternative Therapies Group Incorporated. Thank you very much, Mr. Potvin. That is it for change of ownership, am I correct?
Yes, sir.
Great, thank you very much. So moving on, renewals. So this requires a little bit of introduction. I have mentioned previously that my intent for both renewals and for final licenses is to consider them as a roster unless there is an explicit request by 1 or more commissioners to remove 1 or more from the rosters. So we've made progress here. We're not totally there yet, but we've made progress here. So we're not going to be able to do the entire list, which I believe is 20, if I'm correct. We're not going to be able to do the entire list as 1 roster, but we're going to do it in 4 pieces. So with apologies ahead of time to Commissioners Title and Doyle, if I haven't gotten this right, please stop me. But the 4 pieces that we're going to do a roster of ones that there are no, at least in advance, requests for conditions, and we'll do that as a roster. There are some that have been requested by Commissioner Doyle to be separated because she has conditions she would like to request. So we'll do that as a second roster. The third roster is there's one license that Commissioner Title has requested be separated from the roster because she has a condition she'd like to request. So that'll be the third roster, a roster of one. And then there are three separate licenses that Commissioner Title has requested needs to recuse herself. So we'll do that as a separate one as well. Okay? So again, to Commissioner Doyle and Commissioner Title, if I don't have this exactly right, I apologize. But let's start with the conditions requested, and then we'll go with the roster that's remaining with no conditions requested, okay? So let me start with Commissioner Doyle. The conditions, and I'm going to do this by the letters that are on the agenda. The ones that we're going to pull out for conditions are 3 for Atlantic Medicinal, which are B, C, and D on this list. P, which is on the next slide, which is Apotheca Incorporated, specifically Fitchburg Holyoke. W, which I guess is on the next slide, which is Revolutionary Clinics, Fitchburg and Somerville. X and Y, which are 7 Point of Massachusetts, 2 vertically integrated facilities. Did I get that list correct?
Yes.
Thank you. Then, Mr. Potvin, you've already made your recommendation, so unless you have anything to say on those additional ones, I'm just going to ask Commissioner Doyle to raise her concern and suggest a condition.
Thank you. I have no comments.
Thank you very much. Commissioner Doyle?
Thank you. It's a very minor condition, but I'd like each of the applicants identified by the chairman to submit an updated timeline within 60 days.
Okay. Any other comments or requests for conditions? Then I'd like to ask for a motion to approve the renewal for the candidates who were just articulated by myself, subject to the condition requested by Commissioner Doyle. Can I have such a motion, please?
So moved.
Can I have a second, please? Second. Let the record show that Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the let the record show the commission unanimously approved those renewals subject to the condition requested by Commissioner Doyle. And I'm hoping that our note-taking ability is such that we got that list right, but I've got my notes here in case we need it. Thank you very much. Commissioner Title has requested condition on one of the applicants, which is M, Sanctuary Medicinals. Again, Mr. Potvin, do you have any comments on that before I ask for Commissioner Title's suggested condition?
No, sir.
Commissioner Title?
First, let me thank the staff because there was a huge change between this set and the previous set. So whatever education and guidance you gave on how to provide progress reports, I appreciate it. I saw the difference. So just one, that was M, Sanctuary Medicinals. This is a proposed condition that is identical to a previous proposed condition, which is that within 60 days, they should submit more information about an annual data review that was described in their submitted diversity plan, describing an audited report by the CEO with employment data, values of contracts and subcontractors, and additional information.
Okay, thank you. Any comments or questions before I ask for a motion? Okay, then I'd like to ask, please, for a motion to approve the renewal of Sanctuary Medicinals LLC, MRR 205544, subject to the condition requested by Commissioner Title. Can I have such a motion, please? Can I have a second, please?
Second.
Let the record show Commissioner Bride made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the commission unanimously approved the renewal of Sanctuary Medicinal, subject to the condition requested by Commissioner McBride. I'm going to go through the remaining roster other than your recusal, and then we'll do the recusal last, if that's okay. So again, I believe I've got this right. So the ones that are now remaining on the roster that no commissioner has flagged that they would like to request a condition, an additional condition, are A, let me go back to A, 1620 Labs, B, Gibbies, F, G, and H, which are all good chemistry, I and J, which is Nova Farms, Q, which is the other Apotheca that was not separated out by Commissioner, or requested to be separated out by Commissioner Doyle, R, which is Coastal Healing, S, which is Cultivate Holding, T, which is Cypress Remedies, and then, I'm sorry I didn't do this exactly in order, but then K and L, which are two of the other revolutionary clinics that were not requested to be separated out by Commissioner Doyle. So that's the roster Can I ask, please, for a motion to approve that, the renewal for that roster?
So moved.
Can I have a second, please? Let the record show that Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show the Commission unanimously approved the renewals for everybody on that roster. Thank you very much. The last two renewals are, or last three, Garden Remedies, which is you, and then two for Temescal Wellness of Massachusetts. Commissioner Title has recused herself. So again, we will treat this as one roster. So there are three renewals: Garden Remedies, which is you, and then the two Temescal Wellness N and O. Are there any requests for additional conditions or concerns? Mr. Poppin, do you have anything down on this?
No comments.
Other than your previous, thank you. Then can I please ask for a motion to approve the renewals for Garden Remedies and the two Temescal Wellness of Massachusetts renewals? Can I have a second? Thank you. Let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner McBride. I will do an individual vote on this. Commissioner McBride? Aye. Commissioner Doyle, is that your name? Doyle?
Aye.
Commissioner Hoffman, aye. Commissioner Flanagan?
Aye.
Thank you. Let the record show that the Commission approved the renewal for the three companies on that roster by a vote of 4 in favor. Commissioner McBride, Doyle, Hoffman, and Flanagan, with Commissioner Title recusing herself. Thank you. Can we get her back? Thank you very much. I was trying to figure out, I know you have one more recusal coming up on provisional, but I'm not sure that's the first one that's coming up. No, it's not, so I apologize. We're going to do final licenses, and then, again, on final licenses, since we've already had extensive conversations about these in the provisional licensing process, we're going to try to do this as a roster. I am not aware of any commissioner's desire to pull any one of these off the roster. Is that correct? Commissioner Tuttle, did I miss something?
Sorry, I didn't know you were supposed to submit those separately, but I do have several abstentions.
Well,
and-
but abstentions are fine. So you do want to treat this separately? Would you help me out then?
Yes, just give me a second.
Yeah, sure. Take your time. Would you do it by the letter on the agenda for me?
Yes,
please?
so if, this is actually pretty clean. If we just separate them into two rosters.
So give me the
And the first is A through G,
A through G.
and the second is H through J.
Great. Fine. Okay. Mr. Poppin, aside from the report that you've submitted, would you care to comment on any of these, or your report is sufficient?
I think the enforcement's report is sufficient.
Thank you very much. Then let me take up roster A through G on staff recommendations for final licenses. Are there any questions, concerns, or requests for additional conditions? Commissioner Title.
Just a question on Mayflower Medicinals. Will they still be using the word medicinal in their name?
At this time, there's no pending change of name requests that I'm aware of.
Do we have guidelines for using the words medicinal in your name when it's not a medicinal license?
There is a corollary. They are also an MTC that does have, and some of their operations are co-located, so the logistics over changing their name might be problematic, but
Mr. Executive Director.
Sure. Thank you, Mr. Chairman, and thank you as well, Commissioner Title. I think this is something that is discussion worthy and has kind of been discussed among staff as these are considered. What is the approach going to be? And I guess without getting ahead of myself, because we really haven't, there is no solution in mind yet. This is something we have begun discussions on as far as co-location, as well as the term medicinals and other related terms and the appropriateness of such an indication, how it is perceived both within the industry as well as to the general public regarding what the actual operations are for that entity. So I guess in a way I'm teasing that this is something we're spending a lot of time thinking about internally and hope to bring an approach to the Commission for your consideration.
I'm comfortable with that. Thank you.
Commissioner Flanagan, did you?
Is this something that we can take up as a further discussion during the next regulatory process, or is it more administrative?
I think both, frankly, as far as we would explore both, and I think be prepared to make a recommendation at some point, but also I think it would be entirely appropriate as a regulatory matter as well.
Commissioner Doyle?
Mr. Chairman, on a similar note, just looking at the name of the first entity on the list.
The first
Entity on the list.
253.
Number A and B.
Mhm.
There's a reference to organics,
That's right.
and obviously in normal mainstream, you have to meet a certification requirement to advertise yourself as organics. It sort of exists in the cannabis world, largely on the West Coast, to my knowledge, but do we have any information about this representation of organics?
It does fall within the context of the previous mention that I made as far as the naming. That in particular, I think, raises a labeling question as well regarding what can be on a label versus in how that squares or reconciles with the requirement of the commission's regulations that your name be on the label, but the word organic being permitted on a label. So that's actually what I think initiated the discussion internally of how best to handle that, both in the interim as well as a pending or potential regulatory matter as well. So my hope and expectation is that we can continue to explore that and really dig in on it, but also hopefully bring a recommendation to the commission at some point in the future.
Thank you.
But your point is well taken. I think something we've identified as something we should consider.
Figured you did.
Thank you very much. So for the roster A through G, are there questions, comments, or requests for additional conditions? Other questions or comments, excuse me. Then I'd like to ask, please, for a motion to approve the staff recommendation to issue final licenses to companies A through G on this list.
So moved.
Can I have a second, please?
Second.
I think it was Commissioner McBride. Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
All opposed? Commissioner Title?
Abstain.
Let the record show that the commission approved the staff recommendation to issue final licenses for companies A through G on this roster, with the vote being 4 in favor, Commissioners McBride, Doyle, Hoffman, and Flanagan, with Commissioner Title abstaining. Thank you. Next, let's move on to the second roster, or sub-roster, if you will, HIJ on this list. Commissioner Title, do you have concerns or requested conditions?
No.
Anybody else have questions or concerns? Then let me ask, please, for a motion to approve the staff recommendation to issue final licenses to companies H, I, and J on this list.
So moved.
Can I have a second, please?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show the commission unanimously approved the staff recommendation to issue final licenses to companies H, I, and J on this roster. Thank you. Moving on, we've got provisional licenses, and I believe you're, Commissioner Tyler, you're recusing yourself for the first 3. Is that correct? All 3 of Apical?
Yep.
Okay, thank you. And again, because this is the first time we are being given information and an opportunity to discuss, we'll do these separately. There, I think there's a total of, well, there's a large number of them. I don't think
There's 20 of them.
There's 20, that's what I thought. I was about to say 20, but I wasn't sure. So we will do these separately. Let's start with, I'm sorry, I'm going backwards. Start with Apical Organics LLC. Mr. Potvin, you're up. I got you off the hook for renewals and for finals, so I hope that you saved your energy for provisional.
I was getting ready for them to be done as a roster as well, but I do it like this.
I'm the only one allowed to tell jokes here. No, I'm kidding.
The first 2 licenses will be done as one, the
Yes.
cultivation and product manufacturing. The applicant here is Apical Inc.
To Apical Incorporated, MPN 281333, product manufacturing, subject to the additional condition requested by Commissioner McBride. Thank you. Next is Apical Incorporated, MRN 281246, retail. Mr. Potvin?
Thank you, Mr. Chairman. The applicant here again is Apical Inc. The
I'm
proposal
sorry, did I mispronounce? Is it, do you know if it's Apical or Apical?
might be Apical.
I don't know. I just want to make sure that I'm not mispronouncing it, but I guess we'll find out. We'll hear back.
The
Go ahead,
proposed,
sorry for the interruption.
The proposed location is 19 Wamelco Road in East Hampton. The license being sought here is a retail license. The same individuals and entities associated with the previous license applications exist on this one as well. The applicant here did execute a host community agreement on April 19th of 2018. They conducted a community outreach meeting on November 1st of 2018. The commission did receive a response from the municipality on August 12th of 2019, stating that the applicant was in compliance with local ordinances and bylaws. The applicant did submit a positive impact plan, which has the same goals that were previously discussed. Again, there were no concerns arising on the background checks on any of these individuals or entities. The applicant here states that they could be operational for this license within 6 months of receiving its provisional license. The applicant, again, did submit a diversity plan with the same goals that were previously discussed. And for this application, because it's a retail application, they did submit a plan for obtaining marijuana and marijuana products. Therefore, Commission staff do recommend issuing a provisional license with the conditions before you.
Thank you very much, Mr. Potvin. Are there questions or comments or requested conditions? Commissioner McBride? Then, please, could I ask for a motion to approve the staff recommendation to issue a provisional license to Apical Incorporated MRN 281246 Retail?
So moved.
Can I have a second, please? Let the record show that Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. Commissioner McBride, your vote? Aye. Commissioner Doyle?
Aye.
Commissioner Hoffman, aye. Commissioner Flanagan? Let the record show that the commission approved the staff recommendation to issue a provisional license to Apical Incorporated MRN 281246 Retail with a vote of 4 in favor. Commissioners McBride, Doyle, Hoffman, and Flanagan, with Commissioner Tittle recused. Thank you. Could we get Commissioner Tittle back? Somebody? Thank you very much. I think that's the last time you're going to have to leave the room, right? Well, I don't have any other recusal, so there's no other reason I can think of making you leave the room. So, thank you very much. Next, are Basque Incorporated separate or together?
Together.
Together. So let's consider Basque Incorporated MCN 282211, Tier 3 Indoor Cultivation, and Basque Incorporated MPN 281702, Product Manufacturing. We'll have separate votes, but go ahead with your discussion on both, please, Mr. Potvin.
Thank you, Mr. Chairman. The applicant here is Basque Inc. The proposed location is 7 Campanelli Drive, located in Freetown, Massachusetts. 2 licenses being sought are a Tier 3 Indoor Cultivation license and a Product Manufacturing license. This applicant does have 2 additional retail applications that are in the licensing queue, as well as a fully licensed medical marijuana treatment center located in Fairhaven. The individuals associated with this application include Melanie Dixon, Timothy Coe, Joanne Lebanon, and Chapman Dickerson. Entities associated with this application include Pequod Principal Solutions, LLC, as a parent company. This applicant was an MTC priority applicant. They did secure a host community agreement on January 10th of 2019. A community outreach meeting was held on December 28th of 2018. The commission did receive a municipal response on September 18th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following goals. First, participate in 4 community cleanup events in Fall River, Taunton, and New Bedford. Second, host 2 cultivation and fundraising workshops for individuals with past drug convictions that are also from Fall River, Taunton, or New Bedford. And lastly, number 3, 10% of Basque's workforce will be from Fall River, Taunton, or New Bedford. There were no concerns arising from the background checks on any of the individuals or entities associated with this application. There were some disclosures, however, none of the disclosures raised any suitability issues. The applicant states that they could be operational for this location within 4 months of receiving its provisional license. The applicant did submit a diversity plan, which includes the following. Number 1, 10% of Basque workforce will be women, minorities, veterans, people with disabilities, or people of all gender identities and sexual orientations. And number 2, 5% of Basque's management and executives will be women, minorities, veterans, people with disabilities, or people from all gender identities and sexual orientations. As this is a cultivation and product manufacturing application, they did submit a cultivation plan as well as a list of products that they plan on producing. Therefore, commission staff do recommend issuing a provisional license with the conditions before you.
Thank you very much, Mr. Potvin. Are there questions or comments or requests for conditions? Commissioner Tittle?
I have a proposed condition to
For both?
update the,
For both,
Excuse me?
there's 2 licenses that we're talking about here, so I just want to make sure that you're requesting condition for both.
for both.
We're doing C and D and E. We're going to vote separately, but I just want to make sure you're asking for a condition on both.
Yes, for both.
Okay,
Thank
sorry.
you for checking. No, I appreciate that.
Thank you.
Clarity. For the diversity plan, so the condition is to update the goal, which is that at least 10% of Basque's workforce and 5% of management and executive positions will be comprised of individuals from the above listed groups. And then at that point, there's both a what I believe is a copy and paste error where they noted people of all gender identities. And then it's just objectively unreasonable for the goal to be 10% and then to include women. I'm getting increasingly concerned about these these kinds of mistakes, because I've been bringing it up for months, and where it could be a typo, and we're still seeing that typo, and I'm reading, not to single them out, but in their plan, they've written, our plan is advertising and training for the above listed groups, and then given the typos, that I'm not seeing any thoughtfulness as to what that advertising to those groups or the training to those groups would entail, and I'm not sure they even read the list of the groups. And so I hope that when the new guidance is ready, we're aiming for the next meeting, that can help address these problems. But between that and then the diversity statistics that we see every meeting, which show that we're worse than other industries. The cannabis industry is worse in terms of diversity, and we did implement the requirement for this plan to try and preempt that. And then with the renewals, it's gotten better, but I still get a sense when I read the renewals that they haven't thought about implementing their plan until the last minute. I'd like to have a discussion at the next meeting when we talk about the guidance about what we can do about this.
Absolutely, I think that's perfectly appropriate and necessary. I would ask you, though, do you have specific conditions to request for these two licenses?
Yes.
I would completely agree with your first point.
Thank you, yes. So the condition is to update the diversity plan goals.
Any other comments or questions or requested conditions? Commissioner McBride?
Is it okay for me to talk about product manufacturing?
Yeah, we're talking about both, so just go ahead.
So, two. One is that listed in their list of products that they're going to produce are chocolate-covered espresso beans. I would just like for the director of investigations or our inspectional staff to put eyes on that product and what the packaging is going to look like for it, because it's going to be difficult to affix the contains THC and the marks that we have out there. It's going to have to be on the packaging. I just want to make sure that we know what it looks like in the package and out of the package, please. The second is a clarification in their security plan on incident reporting, that pursuant to 500-110-9A, law enforcement and the commission are informed of any incidents. Currently, the security plan states that law enforcement is informed and that a written report is filed within 10 days to the commission. I know that they understand the need to immediately inform both law enforcement and the commission, because in the diversion prevention plan it does accurately state that. I just want it to be reflected in the security plan as well, that it's the requirement to immediately notify the commission as well as law enforcement of any diversion, and then follow through with a written report within 10 days.
So just to make sure I'm tracking, the first condition you requested, Commissioner McBride, is with respect to the product manufacturing license. The second condition applies to both licenses?
It applies to the product manufacturing license.
So
as well.
both conditions apply just
Yes.
to product manufacturing, whereas your condition applies to both. Is that correct? Okay. Any other questions or conditions requested? Fine, then let me ask, please, for a motion, please, to approve the staff recommendation to issue a provisional license to Basque Incorporated, MCN 282211, Tier 3 indoor cultivation, subject to the condition requested by Commissioner Tidal. Okay. Let the record show Commissioner McBride made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show the commission unanimously approved the staff recommendation to issue a provisional license to Basque Incorporated, MCN 282211, Tier 3 indoor cultivation, subject to the condition requested by Commissioner Tidal. Let me next ask for a motion to approve the staff recommendation to issue a provisional license to Basque Incorporated, MPN 281702, product manufacturing, subject to the condition requested by Commissioner Tidal and the two conditions requested by Commissioner McBride. Can I have a second, please?
Second.
Let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye. Aye.
Let the record show the commission unanimously approved the staff recommendation to issue a provisional license to Basque Incorporated, MPN 281702, product manufacturing, subject to the conditions requested by Commissioners Tidal and McBride. Thank you. Moving on, we have three for community growth partners. I presume the first one is separate from the second two?
That's correct, sir.
So let's go through the first number F. Or letter F, excuse me, Community Growth Partners, Great Barrington Operations LLC, MRN 282695 Retail. Mr. Potvin.
Thank you, Mr. Chairman. As you stated, the applicant here is Community Growth Partners, Great Barrington Operations LLC. The proposed location is 783 South Main Street, located in Great Barrington. The license being sought here is a retail license. The applicant is not an applicant or licensee for any other license type. However, individuals and entities associated with this application are also associated with the next two applications. Two individuals associated with this application include Charlotte Hanna and Marcus Williams. Entities associated with this application include Community Growth Partners, MA Real Estate LLC, and Community Growth Partners Holdings LLC. This applicant is an economic empowerment applicant. The applicant did secure a host community agreement on March 20th of 2019. They conducted a community outreach meeting on January 31st of 2019. The commission did receive a municipal response from the municipality on September 25th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following goals. 1, applicant plans to be an accelerator for generational wealth building opportunities. 2, offer monthly industry-specific educational seminars. And number 3, commit 3% of its annual net profits to its criminal justice reform program. There were no concerns arising from the background checks on any of the individuals or entities associated with these applications. There are also none of the usual disclosures. The applicant states that it could be operational within 2 months of receiving its provisional license. The applicant did submit a diversity plan, which includes the following goals. 1, establish a diverse ownership and leadership team that exceeds 75% of disenfranchised populations and 51% of equity ownership. Number 2, recruit 75% of individuals from disenfranchised populations. And 3rd, utilize suppliers of goods and services that support diversity. As this is a retail application, they did submit a plan for obtaining marijuana or marijuana products. Therefore, Commission staff do recommend issuing a provisional license with the conditions before you.
Thank you very much, Mr. Potvin.
Mr. Chairman.
Yes, Commissioner Flanagan.
Mr. Chairman, I have a question / condition for the positive impact plan for this entity. Specifically, my concern is that in the plan, it says for goal number 2, be a reliable source for cannabis education and awareness. We have regulations surrounding what can and cannot be discussed, particularly health benefits. But yet in their number 3, community education and outreach, it says that they will offer monthly education seminars to provide an opportunity for local community members to learn and ask questions about the many uses and health benefits of cannabis. So my question is that under 935 CMR 500.105, Section 4, subsection 6B, does this go against the fact that you cannot state the health benefits unless you have substantial evidence or clinical data? So do they have the data? And if they do, fine. If they don't have the data, then my condition is that they need to rewrite what their education outreach is going to look like.
Thank you. Other questions or comments or requested conditions? Commissioner Tuttle?
I agree with that condition, but I just wanted to also note this is maybe the best, one of the best, if not the best, positive impact plans I've seen yet.
Yeah, I agree. Other questions or comments? Great. Then could I ask please for a motion to approve staff recommendation to issue a provisional license to Community Growth Partners Great Barrington Operations LLC, MRN 282695 retail, subject to the condition requested by Commissioner Flanagan?
So moved.
Have a second, please?
Second.
I think, let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Aye.
Let the record show the Commission unanimously approved the staff recommendation to issue a provisional license to Community Growth Partners Great Barrington Operations LLC, MRN 282695 retail, subject to the additional condition requested by Commissioner Flanagan. Thank you. Mr. Potvin, we're going to do the next two together for Community Growth Partners.
Yes, sir.
Please go ahead. Thank you.
Thank you. The applicant here is Community Growth Partners Northampton Operations LLC. The proposed location is 20 Ladd Avenue, located in Northampton. The two licenses being sought are a Tier 3 indoor cultivation license and a product manufacturing license. The individuals and entities associated with this application are the same as were previously discussed. Again, this is an economic empowerment applicant. The applicant did execute a host community agreement on April 26th of 2019. The applicant conducted a community outreach meeting on January 29th of 2019. The commission did receive a response from the municipality on September 20th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did again submit positive impact plan, which includes the same goals that were previously discussed. Also, they did submit a diversity plan that has the same goals that were previously discussed. As this is a cultivation and product manufacturing application, they did submit a summary of their cultivation plan, as well as a list of products that they plan on producing. Therefore, Commission staff do recommend issuing provisional licenses with the conditions before you.
Thank you, Mr. Potvin. Are there questions or comments or requests for conditions on G and H? Okay. Then let me ask, please, for a motion to approve the staff recommendation to issue a provisional license to Community Growth Partners Northampton Operations LLC, MCN 282162, Tier 3 Indoor Cultivation. Can I have such a motion, please?
So moved.
Can I have a second, please?
Second.
Let the record show, Commissioner McBride, are you okay? Let the record show that Commissioner Doyle made the motion to approve, seconded by Commissioner Tidal. All in favor? Let the record show that the Commission unanimously approved the staff recommendation to issue a provisional license to Community Growth Partners Northampton Operations LLC, MCN 282162, Tier 3 Indoor Cultivation. Let me next ask for a motion, please, to approve the staff recommendation for Community Growth Partners Northampton Operations LLC, MPN 281677, Product Manufacturing.
Same condition.
With the same commission, I'm sorry, I apologize, same condition requested by Commissioner Flanagan.
So moved.
Can I have a second, please?
Second.
Let the record show that the commission, I'm sorry, all in favor?
Aye.
Let the record show that the commission unanimously approved the staff recommendation to issue a provisional license to Community Growth Partners Northampton Operations LLC, MPN 281677, product manufacturing, subject to the additional condition requested by Commissioner Flanagan. I want to just go back on the record. I don't know the vote on the previous one, or letter G, included Commissioner Flanagan's condition. I think I might have omitted that. My apologies if I did so, Commissioner Flanagan. So, go ahead.
To remedy that, there could be a motion to reconsider that vote. But if that's reconsidered, then add the condition.
Fine. So I'd like to do that. Could I have a motion to reconsider the vote on G, please?
So moved.
Can I have a second?
Second.
All in favor?
Aye.
Let the record show that the Commission unanimously approved reconsidering the vote on G. So let me now ask for a motion to approve the staff recommendation for Community Growth Partners Northampton Operations LLC, MCN 282162, Tier 3 Indoor Cultivation, subject to the condition requested by Commissioner Flanagan. Can I have such a motion, please?
So moved.
Can I have a second?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Tidal. All in favor?
Aye.
Let the record show the Commission unanimously approved the staff recommendation to issue a provisional license to Community Growth Partners Northampton Operations LLC, MCN 282162, Tier 3 Indoor Cultivation, subject to the additional condition requested by Commissioner Flanagan. Thank you. Next, we have three for Four Daughters Compassionate Care Incorporated. And, the first two we're going to do simultaneously and then retail separately.
Yes, sir.
Go ahead, please, Mr. Poffman.
Thank you. The applicant here is Four Daughters Compassionate Care Incorporated. The proposed location is 1200 General Edwards Highway, located in Sharon. The two licenses being sought are Tier 4 Indoor Cultivation License and a Product Manufacturing License. The individuals associated with this application include Brian Stryer, Darren Henry, Samuel O'Dorff, and George Achos. One entity other than the applicant itself, two entities other than the applicant itself are associated with this application. That's Verano Four Daughters Holdings LLC, which is a parent company, and Verano Holdings LLC, which is a capital contributor. The applicant here did execute a host community agreement on June 19th of 2018. The applicant completed and conducted a community outreach meeting on February 4th of 2019. The commission did receive municipal responses on September 10th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following goals. First, provide funds to expunge at least 10 felony records per year. 2, donate $5,000 to the Equitable Opportunities Now organization. And third, participate in at least 2 job fairs per year. There were no concerns arising from the background checks on the individuals or entities associated with this application. The applicant did submit a proposed timeline that states that they could be operational within 4 months of receiving its provisional license. The applicant did submit a diversity plan, which includes recruiting at least 5 diverse individuals. Second, conduct on-site diversity training once every quarter. And third, sponsor general industry-specific training for veterans twice a year. The applicant did submit a cultivation plan as well as a list of products that they plan on producing. Therefore, Commission staff do recommend issuing provisional licenses with the conditions before you.
Thank you, Mr. Potvin.
Mr. Chairman,
Commissioner Flanagan.
I have serious concerns with the monetary donations that are being provided to Equitable Opportunities Now and also to Elevate. My concern is that these are large organizations, and I want to make sure that the donations are specific for the areas that they've outlined in their plan for the cities and towns that they've outlined. So my question is, for the first one, it says that at Equal Opportunities Now, the money will be used to conduct programming and job trainings, workshops, and seminars on different facets of the industry, as well as networking and business events to support equity entrepreneurs in the cannabis space. I want to make sure that they're specific to the disproportionately impacted areas that they've decided to focus on. And then secondly, Elevate says, Elevate New England will use these resources to offer more educational events around Massachusetts. Again, I want to make sure that this money is going specifically to the towns they were intended for and not just put into some pool of money that could be used wherever.
You're proposing that as a condition?
Yes.
Okay, thank you. Other comments, questions? Commissioner Title?
Could I offer a friendly amendment to that condition? That the condition be that the donations go to disproportionately harmed communities as defined by our regulations, not necessarily specific cities or towns?
Only if they don't, if they rewrite the positive impact plan to not say that they're going to specifically impact Brockton, Mansfield, Taunton, and Walpole. Because they're specifically saying the 4 that are here. So if they're going to do something else, then I think it goes against what their intent was.
So the condition is to rewrite it to make sure that the donations are benefiting disproportionately harmed communities
In Massachusetts, yeah.
in Massachusetts.
But if,
Specifically, go ahead.
right, so if they choose to take out the 4 cities and towns, then that's their choice. If not, and they want to keep these 4 because they made some kind of commitment, then the money needs to, the programming needs to be proven that it's in these 4 communities.
Mr. Chairman?
Commissioner Doyle?
And this will be the same for the other licenses for this
For
particular
all 3
company?
for 4 daughters? Yeah, go ahead.
I believe that the company relied upon their status as a priority RMD in pursuit of their adult licensure, and I would like to add a condition that they need to update the timeline for their RMD within 60 days.
Yep. Okay. Other concerns or questions or requested conditions? Commissioner Title?
Just a proposed condition under the diversity plan with the goal to hire 5 diverse candidates to define that term.
Define the term diverse.
Diverse candidates.
Yep.
Thank you.
Okay. And for the updated timeline for the revisions to the impact plan that Commissioner Flanagan raised and to your comment on all 3, those are applying to all 3 licenses, correct?
They are.
All 3 applications. Okay. Anything else? Yeah, Commissioner Title.
Just because I go above and beyond on recusals and disclosures, I just want to disclose that the 2 organizations that would be getting the donations that we just discussed, I'm very close to those 2 organizations, but it doesn't meet the need for a recusal.
I
from my view.
appreciate you raising that, but I agree with your assessment.
Thank you.
And we'd hate to see you have to leave again, so.
Yeah, you did say that.
We've been there, done that. Anything else? Any other conditions or concerns? Okay, then I'd like to ask, please, for a motion to approve the staff recommendation to issue a provisional license to 4 Daughters Compassionate Care Incorporated, MCN 282243, Tier 4 indoor cultivation, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. Can I have a second, please?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show the commission unanimously approved the staff recommendation to issue a provisional license to 4 Daughters. I don't know why I'm having a problem with 4 Daughters. 4 Daughters Compassionate Care Incorporated, MCN 282243, Tier 4 indoor cultivation, subject to conditions requested by Commissioners Doyle, Flanagan, and Title. Thank you. I would next like to ask for a motion, please, to approve the staff recommendation to issue a provisional license to 4 Daughters Compassionate Care Incorporated, MPN 281715, product manufacturing, again, subject to conditions requested by Commissioners Doyle, Flanagan, and Title. Can I have such a motion, please?
So moved.
Can I have a second?
Second.
Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show that the commission unanimously approved the staff recommendation to issue a provisional license to 4 Daughters Compassionate Care Incorporated, MPN 281715, product manufacturing, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. Thank you. Can I just ask for that motion?
Oh.
No, I'm sorry. I think we're fine. Did I ask for a motion on that? Have we voted on that?
Retail? No.
No, the retail one is next, so we're fine with manufacturing. Thank you. Mr. Potvin, we now will move into retail.
Yes, sir.
That's the last of the Four Daughters Compassionate Care Incorporated. Before you do so, can I just request or ask all the conditions requested by Commissioners Title, Flanagan, and Doyle apply to this license, would be applied to this license as well? Yeah. Go ahead, Mr. Potvin.
Thank you, Mr. Chairman. Again, this applicant is Four Daughters Compassionate Care Incorporated. The proposed location is 2 Merchant Street, Unit 1, also located in Sharon. The license being sought here is a retail license. The individuals and entities previously discussed are also associated with this application. The applicant did execute a host community agreement on June 19th of 2018. A community outreach meeting was held on February 4th of 2019. The commission did receive a municipal response on September 10th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant again submitted a positive impact plan, which is the same goals that were previously discussed. The applicant also submitted a diversity plan with the same goals that were previously discussed. As this is a retail application, they did submit a plan for obtaining marijuana and marijuana products. Therefore, commission staff do recommend issuing a provisional license with the conditions before you.
Thank you, Mr. Potvin. In addition to the 3 conditions that were requested for the other Four Daughter Compassionate Care Incorporated licenses, are there any other concerns or conditions? Then could I ask, please, for a motion to approve the staff recommendation to issue a provisional license to Four Daughters Compassionate Care Incorporated, MRN 281552, retail, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title?
So moved.
Can I have a second, please? Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show that the Commission unanimously approved the staff recommendation to issue a provisional license to Four Daughters Compassionate Care Incorporated, MRN 281552, retail, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. Thank you. Mr. Potvin, these are separate, so let's start with Green Star Herbals Incorporated, MRN 282034, retail.
Thank you, Mr. Chairman. The applicant is Green Star Herbals Incorporated. The proposed location is 200 Beechman Street, located in Chelsea. The license being sought here is a retail license. This applicant also has 2 additional retail applications that are in the queue. The individuals associated with this application include Thomas Morey, James Morey, John Herendine, and Napoleon Brito. There is no other entities other than the applicant itself that appear to have any ownership or control over this entity. This applicant is a general applicant. They did execute a host community agreement on September 21st of 2018. The applicant did conduct a community outreach meeting on September 20th of 2018. The commission did receive a municipal response on September 23rd of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following goals. First, hire 50% of residents of Chelsea or another area of disproportionate impact. 2, donate $2,500 annually to Green Roots Incorporated. And 3rd, donate $5,000 to Chelsea Chamber of Commerce. There were no concerns arising from the background checks on any of the individuals or entities associated with this application. The applicant did submit a proposed timeline that states that they could be operational within a year of receiving its provisional license. The applicant did submit a diversity plan, which includes hiring 20% of staff from commission-approved areas of diversity. As this is a retail application, they did submit a plan for obtaining marijuana and marijuana products. Therefore, commission staff do recommend issuing a provisional license with the conditions before you.
Thank you very much, Mr. Potvin. Are there questions or requests for additional conditions? Commissioner McBride?
I just have a request that, similar to my earlier request, that they make it clear that law enforcement and the commissioner are notified of any security breach immediately and issue the written report within 10 days. There was a similar sort of issue that wasn't clear in their security plan. Thank you.
Okay, thank you. Anything else, Commissioner Title?
Yes, applicable to both, a proposed condition to the diversity plan to update the 20% from commission-approved areas of diversity, both in terms of the people of all gender identities typo, and also that 20% is objectively unreasonable, so to change that.
You got that, Mr. Potvin?
Yes, sir.
Anything else? Okay, then I'd like to ask, please, for a motion to approve Green Star Herbals Incorporated, MRN 282034, retail, subject to the conditions requested by Commissioners McBride and Title. Can I have such a motion, please?
So moved.
Can I have a second?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Title. All in favor?
Aye.
Let the record show that the Commission unanimously approved the staff recommendation to issue a provisional license to Green Star Herbals Incorporated, MRN 282034, retail, subject to the conditions requested by Commissioners McBride and Tidal. Thank you. The second Green Star Herbals Incorporated application is MRN 282048, retail. Mr. Potvin.
Thank you, Mr. Chairman. Again, the applicant is Green Star Herbals Incorporated. Proposed location is 76-100 Pleasant Street in Dracut. The license being sought here is a retail license. The individuals associated with the previous application are also associated with this application. The applicant did execute a host community agreement on November 6th of 2018, and the applicant did conduct a community outreach meeting on October 25th of 2018. The Commission did receive a municipal response on September 23rd of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan with the same goals that were previously discussed. Additionally, the applicant did submit a diversity plan with the same goals that were previously discussed. Again, this is a retail application, so they did submit a plan for obtaining marijuana and marijuana products. Therefore, Commission staff do recommend issuing a provisional license with the conditions before you.
Thank you, Mr. Potvin. So I'm assuming that the conditions on the previous license requested by Commissioners McBride and Tidal are also relevant to this application. Are there additional requests for conditions or questions? Great. Then let me ask, please, for a motion to approve the staff recommendation to issue a provisional license to Green Star Herbals Incorporated, MRN 282048, retail, subject to the conditions requested by Commissioners McBride and Tidal. Can I have a second?
Second.
Let the record show that Commissioner McBride made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the Commission unanimously approved the staff recommendation to issue a provisional license to Green Star Herbals Incorporated, MRN 282048, retail, subject to the conditions requested by Commissioners McBride and Tidal. How you doing, Mr. Potvin?
Doing very well, sir.
Doing better than me, I think, so keep going. We're getting there. HVV Massachusetts Incorporated, we're going to do together in separate votes. Is that correct?
Yes, sir.
Please go ahead.
Thank you. The applicant here is HVV Massachusetts Incorporated. The proposed location is 2 Opportunity Way in Newburyport, Mass. The 2 licenses being sought are a Tier 4 indoor cultivation license as well as a product manufacturing license. The 2 individuals associated with this application include Michael Reardon and Edward Louth. One entity other than the applicant itself is associated with this application. That's HV Ventures MA LLC, which is the owner and capital contributor. The applicant did execute a host community agreement on April 25th of 2019. The community outreach meeting was held on May 29th of 2019. The Commission did receive a municipal response on October 7th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following goals: donate $25,000 annually to Girls Leap, provide a minimum of 40 hours volunteer time to Girls Leap, and third, hire 15% of individuals from designated areas of disproportionate impact. There were no concerns arising from the background checks on any of the individuals or entities associated with this application. The applicant did submit a proposed timeline that states that they could be operational within a few weeks of receiving their provisional license. The applicant did submit a diversity plan, which includes the following goals: 1, hire 50% women and 25% minorities. Secondly, work with 25% of businesses that are from Commission-identified areas of diversity. As this is a cultivation and product manufacturing application, they did submit a cultivation plan as well as a list of products that they plan on producing. Therefore, Commission staff do recommend issuing provisional licenses with the conditions before you.
Thank you, Mr. Potvin. Questions or comments or requests for conditions? Commissioner Doyle?
Hi.
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 Right back at you.
How you doing?
You don't want to ask that.
Okay.
At least I don't want to answer that in public, so keep going.
Got it. I believe this applicant relied upon their priority RMD status to pursue their adult application, and I note that they appear to be making progress on their approach to being operational on the medical side. Their timeline is a little out of date, though, so could we add that timeline? And
Updated timeline.
Yeah, I just want to recognize this is not because they're not doing anything. It's just getting a better idea of where they're at.
Great. Commissioner Flanagan?
Mr. Chairman, the only question that I have is that, and I could have missed it, but was there a letter received saying that Girls Leap would take the money?
I don't have that. I couldn't answer that.
So if there isn't a letter, I'd like them to have the letter before the final licensure.
We can confirm that.
Thank you.
You'd like that condition?
Yes.
Okay. Any other comments or questions or requests for conditions? Okay, then can I ask for a motion, please, to approve the staff recommendation to issue a provisional license to HVV Massachusetts Incorporated, MPN 281693, product manufacturing, subject to the conditions requested by Commissioners Doyle and Flanagan? Can I have a second, please? Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show the Commission unanimously approved the staff recommendation to issue a provisional license to HVV Massachusetts Incorporated, MPN 281693, product manufacturing, subject to the conditions requested by Commissioners Doyle and Flanagan. Let me ask, please, for a motion to approve the staff recommendation to issue a provisional license to HVV Massachusetts Incorporated, MCN 282198, Tier 4 indoor cultivation, again, subject to conditions requested by Commissioners Doyle and Flanagan. Can I have such a motion, please?
So moved.
Can I have a second?
Second.
Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Aye.
Let the record show the Commission unanimously approved the staff recommendation to issue a provisional license to HVV Massachusetts Incorporated, MCN 282198, Tier 4 indoor cultivation, subject to the conditions requested by Commissioners Doyle and Flanagan. Thank you. Just Healthy LLC will do the first two, and then retail separately. Mr. Potvin?
The applicant here is Just Healthy LLC. The proposed location is 1010 Ryan Road in Northampton. The two licenses being sought are a Tier 7 indoor cultivation license as well as a product manufacturing license. The individuals associated with this application include the following: William Phelan, Neil Phelan, Brett Sproul, Kent Kefner, Peter Harveth, Ryan Logan, Mark Lehman, Gene Schottenstein, Stephen Stout, Timothy Moore, Carly Posner, and Igor Galitsky. Two entities associated with this application include GGB Massachusetts LLC, which is the sole owner of Just Healthy LLC, and Green Growth Brands Incorporated, which is the parent company of GGB Massachusetts LLC. This applicant is an MTC priority applicant. They did execute a host community agreement on January 9th of 2019. A community outreach meeting was held on September 19th of 2018. The commission did receive a response from the municipality on September 20th of 2019, stated that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following goals: provide monetary donations to programs located in Holyoke, give hiring preferences to individuals who reside in Holyoke, and third, create a mentorship program to assist aspiring cannabis business owners and operators in Holyoke. There were no concerns arising from the background checks on any of the individuals or entities associated with the application. They did submit a proposed timeline that states that they could be operational within 1 year of receiving its provisional license. The applicant did submit a diversity plan, which includes the following goals: recruit diverse employees at all levels. Second, develop and retain diverse employees by promoting an environment that values differences. Third, increase the diversity of employees in senior and management positions. As this is a cultivation and product manufacturing application, they did submit a summary of their cultivation plan as well as a list of products that they plan on producing. Therefore, Commission staff do recommend issuing provisional licenses with the conditions before you.
Thank you, Mr. Potvin.
Mr. Chairman?
Yes, Commissioner Flanagan.
Again, I could have missed it, but I didn't see a letter accepting the donation that was going to be made to the Homework House in Holyoke. So they could have that if it was not in the file.
Okay, thank you. Other conditions or concerns? Commissioner Title?
I'd like to propose a condition to add quantified, measurable goals to the diversity plan.
Thank you. Any other concerns? Commissioner Doyle?
Thank you. Again, I believe this applicant relied on their priority RMD status to pursue their adult license, so I'd just like to ask them to update their timeline for their medical operation.
Okay, thank you. Other conditions or concerns? Okay, then I would like to ask for a motion to approve the staff recommendation for Just Healthy LLC, MCN 281866, Tier 7 indoor cultivation, subject to the additional conditions requested by Commissioners Doyle, Flanagan, and Title.
So moved.
Second.
Let the record show that the motion was made by Commissioner Doyle, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show that the Commission unanimously approved the staff recommendation to issue a provisional license to Just Healthy LLC, MCN 281866, Tier 7 indoor cultivation, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. I did product manufacturing, I'm sorry. I just misspoke. So we just approved HVV Incorporated, MPN 281693, product manufacturing. I would now like to ask for a motion to approve the staff recommendation to issue a provisional license to Just Healthy Incorporated, LLC, MPN 281559, product manufacturing, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. We did, so I'd like a motion, please, to approve the staff recommendations subject to those conditions, again, for Q Just Healthy LLC, product manufacturing.
So moved.
Can I have a second?
Second?
Okay. All in favor?
Aye.
Let the record show that the commission unanimously approved the staff recommendation to issue a provisional license to Just Healthy LLC, MPN 281559, product manufacturing, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. We now will move on to Just Healthy LLC, MRN 281863, retail. Mr. Potvin.
Thank you, Mr. Chairman. The applicant here again is Just Healthy LLC. The proposed location is 1010 Ryan Road in Northampton. The license being sought is a retail license. The individuals associated with this application are the same as previously discussed, as well as the entities associated with this application. The applicant here did execute a host community agreement on December 7th of 2018. The community outreach meeting was held on September 19th of 2018. A municipal response was received from the municipality on September 20th of 2019. The applicant did submit a positive impact plan with the same goals that were previously discussed. Again, the applicant did submit a diversity plan with the same goals that were previously discussed. As the applicant is seeking a retail license here, they did submit a plan for obtaining marijuana and marijuana products. Therefore, commission staff do recommend issuing a provisional license with the conditions before you.
Thank you. Aside from, I presuming the three conditions requested by Commissioners Doyle, Flanagan, and Title apply to this license as well. Is that correct? Mm-hmm. Are there any additional requests for conditions or information? Okay. Thank you. Then let me ask, please, for a motion to approve the staff recommendation to issue a provisional license to Just Healthy LLC, MRN 281863, retail, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. Can I have such a motion, please? Can I have a second?
Second.
Let the record show that the motion was made by Commissioner McBride, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the commission unanimously approved the staff recommendation to issue a provisional license to Just Healthy LLC, MRN 281863, retail, subject to the conditions requested by Commissioners Doyle, Flanagan, and Title. Thank you. Next is Old Planters of Cape Ann Incorporated. Mr. Potvin.
Thank you, Mr. Chairman. The applicant here is Old Planters of Cape Ann Incorporated. The proposed location is 300 Newburyport Turnpike, Unit 1 in Raleigh. The license being sought here is a retail license. This applicant does have a medical marijuana treatment center that holds currently a provisional license in Ipswich. The individuals associated with this application include Spencer Kalker, James Sisolak, Daniel Heider, Brian Schuman, Warren Pratt, and Gregory Steiden. One entity other than the applicant itself is associated with this application. It is GGH Incorporated, which is a capital holding company. This applicant is an MTC priority applicant. They did execute a host community agreement on April 22nd of 2019. A community outreach meeting was held on December 12th of 2019. We did receive a municipal response on September 16th of 2019, stating that the applicant was in compliance with local ordinances or bylaws. The applicant submitted a positive impact plan, which includes the following goals. First, 25% of its workforce will fall into areas of disproportionate impact. Second, 20% of contractors, vendors, and suppliers will fall into areas of disproportionate impact. And third, they will plan on donating $10,000 to the Commission's Social Equity Training and Technical Assistance Fund. There were no concerns arising from the background checks on any of the individuals or entities associated with this application. The applicant did submit a proposed timeline that states that they could be operational within 3 months of receiving its provisional license. The applicants did submit a diversity plan, which includes the following goals. First, 50% of its workforce will be comprised of women. Second, 30% of its workforce will be minorities, veterans, people with disabilities, and people of all gender identities and sexual orientations. Third, 35% of supplier and contractors will be women, minorities, veterans, people with disabilities, and people of all gender identities and sexual orientations. The applicant did submit a plan for obtaining marijuana and marijuana products. Therefore, Commission staff do recommend issuing a provisional license with the conditions before you.
Thank you very much, Mr. Potvin. Are there questions or comments or requests for conditions on this license application?
Mr. Chairman,
Commissioner Doyle?
similar to applicants that we've discussed before, I'd like to ask this applicant to update their timeline as to their medical operation.
Thank you. Anything else? Commissioner Title?
Just a minor proposed condition to update the people of all gender identities error in the diversity plan. Thank you.
Anything else? Okay. Thank you. Then let me ask, please, for a motion to approve the staff recommendation to issue a provisional license to Old Planters of Cape Ann Incorporated, MRN 282588 retail, subject to the conditions requested by Commissioners Doyle and Title. Can I have such a motion, please?
So moved.
Have a second?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Title. All in favor?
Aye.
Let the record show that the Commission unanimously approved the staff recommendation to issue a provisional license to Old Planters of Cape Ann Incorporated, MRN 282588 retail, subject to the conditions requested by Commissioners Doyle and Title. We're at the end. One more. Theory Farms LLC, Mr. Potvin.
Thank you, Mr. Chairman. The applicant here is Theory Farms LLC. The proposed location is 26 William Way in Bellingham. The license being sought is a Tier 2 indoor cultivation license. The individuals associated with this application include Brandon Pollock, Nick Friedman, Andrew Linegar, Stephen Derry, and Benjamin Friedman. No other entities other than the applicant itself are associated with this application. The applicant did execute a host community agreement on September 11th of 2018. A community outreach meeting was held on September 18th of 2018. The commission did receive a municipal response from the municipality on August 30th of 2019 stating that the applicant was in compliance with local ordinances or bylaws. The applicant did submit a positive impact plan, which includes the following. Goals: first, donate $5,000 annually to the Massachusetts Recreational Consumer Council. Second, spend 10% of capital expenditures on vendors based in Walpole. And third, hire 10% of individuals from Walpole. There were no concerns arising from the background checks on any of the individuals or entities associated with this application. They did submit a proposed timeline that states that they could be operational within 6 to 7 months of receiving their provisional license. The applicant did submit a diversity plan, which includes the following goals. First, have 30% of management comprised of commission-approved diverse populations. Secondly, hold annual training in Walpole to increase equity in the cannabis industry. As is a cultivation application, they did submit a cultivation plan. Therefore, commission staff do recommend issuing a provisional license with the conditions before you.
Thank you, Mr. Potvin. Are there comments or questions or requests for conditions?
Mr. Chairman.
Commissioner Flanagan.
Relative to the positive impact plan for this license type, there are very specific times that are stated: May 2019 for the employment fair, August 1st for the hiring, completion of hiring, and the analyzing the donations in November of 2019. So I'd like those updated before final licensure for this facility.
Thank you. Anything else? Then could I ask, please, for a motion to approve the staff recommendation to issue a provisional license to Theory Farms LLC, MCN 281657, Tier 2 indoor cultivation, subject to the additional condition requested by Commissioner Flanagan?
So moved.
Can I have a second, please? I'll let the record show that Commissioner Flanagan made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show that the Commission unanimously approved the staff recommendation to issue a provisional license to Theory Farms LLC, MCN 281657, Tier 2 indoor cultivation, subject to the additional condition requested by Commissioner Flanagan. I'm sorry. I really need a break. I really need a break. Is there anything else? How much time would you like? The half hour?
5 to 10?
Pardon? No, I think we should probably let people grab a bite as well. So is a half hour sufficient to everybody?
Yes.
And I've got 5 of 1. We'll just reconvene at 1:30. Thank you very much. And again, I really, let's take a break. That was pretty, I hope everybody got a chance to get some sustenance over that break. I certainly needed it. I presume others did as well. We're doing actually pretty well with respect to time. We have 4 remaining items on the agenda, and my guess is we'll be done between 3 and 3:30. Might go a little further, but we'll definitely be done by 4 at the absolute latest. The first item that's remaining on the agenda is updated guidance with respect to energy and environment. I have said this many times before, but it can't hurt to repeat it. I just wanted to thank Commissioner Doyle for her leadership on this. She constantly tells me that, she's not an expert on this subject. She's just, an old-fashioned municipal attorney that, doesn't know anything at all about technology or science or energy. That might have been true a while ago. It is certainly no longer the case, and she has really become quite the subject matter expert on this. But more importantly than that, just the energy that she's put into this, the time she's put into this, the passion and the leadership she's shown is just remarkable on this incredibly important topic. That being said, I'm going to turn it over to Commissioner Doyle and let her lead the conversation on this new guidance. Would you like me to click for you, or would you like to click for yourself?
Oh, I think I can click for myself.
You know, this is technology we're talking about here.
I know.
Okay.
I'm gonna risk it.
Okay.
I know, so.
I'm going to make fun of you either way, so you really, there's no upside.
Well, with such a nice introduction, there's nowhere I can go but down. So first, before I launch into all of this, I have to recognize all the folks who have also worked on this, because there are many, and they are not only in our agency. In the Executive Office of Energy and Environmental Affairs, General Counsel Tori Kim, as well as Maggie McCary. In our own shop, Matt Giancola and Pauline Nguyen have really helped bring this to the point where we're at today, as well as the rest of the team in providing support for implementation of the guidelines that we're going to talk about in a minute and publish on our website. So quick overview as to where in the licensing and compliance process the updated energy guidance are really going to make a difference. And first, you can see the highlights in yellow are the management and operations profile in the application process. We're going to want to hear some information about energy in the management and operations profile. We're going to hear, I want to hear a lot more at the architectural review stage after a provisional license has been issued. And then as we get further down and further towards operational, we're going to want to see an ongoing engagement with energy monitoring and energy efficiency programs. And when we get to renewal, we're going to want to see some specific reporting, which I will talk about, as well as updates to the information that was originally provided in the architectural review after provisional licensing. So,
Good job.
thank you. Not done yet, unfortunately. Just a quick reminder of all the preparation that went into this, and thank you to the Energy and Environmental Working Group that convened in June 2018 and met multiple times, accepted comment at listening sessions as well as in writing, and then met again to develop guidances and best management practices, some of which are already published and some of which we are going to discuss today, as well as the regulatory process that we just went through. So the themes of the energy guidance are as follows on the slide. We're looking to evaluate energy efficiency, use of renewable energy generation, evaluation and strategies to reduce electric demand, and engagement with energy efficiency programs such as Mass Save. So there's two guidances, a basic guidance that applies to everyone, and then an additional guidance that applies only to cultivation facilities, be it medical or adult. So we'll talk about the basic guidance first, and this is a guidance that hits on the themes that we just went over in the last slide, the energy efficiency, the renewables, the demand, and the energy efficiency programs. All applicants other than transporters or delivery operators are going to be asked to describe their engagement on the issues, the timeline for implementation of any energy efficiency options or renewable energy options, and their plans for upgrades or repairs just in the normal course of upgrading their facility, or in the worst case scenario if existing equipment has failed. The guidances and the checklists that are related to the guidances will provide detailed information regarding specific issues to be addressed at the different points in the process that I highlighted on the slide before. Just to highlight, transporters and delivery operators do have different requirements because they obviously have a different kind of business. We're going to ask them to talk about their consideration of alternative fuel vehicles and, you know, be understanding that not every type of vehicle has an alternative fuel option. But as time and technology progress, we do hope to keep folks engaged in how they are evaluating their alternative fuel vehicles. In addition, they will need to talk about the energy and environmental impact at their base location, their garage, or whatever dispatch location they are going to be operating out of. Moving on to cultivation facilities, and again, cultivation facilities will have to meet the requirements of the basic guidance, but then have additional information because cultivation facilities in particular generate the most usage of energy. So this is all detailed in the regulations, but specific considerations are pertaining to the building envelope, horticultural lighting, HVAC and dehumidification systems, and safety, particularly eye safety. So specifically for the applications process, we are going to want to hear how cultivators are ensuring on a regular basis that their equipment is maintained, calibrated, and operating properly, including their manuals and their procedures for all their major energy-using equipment. And then when it gets to the architectural review process, we are going to want to receive a letter from a qualified professional, and I'll describe what the qualifications necessary are. It's one of two letters, the energy compliance letter or the energy compliance exemption letter. And then secondly, we'll want to have a third-party safety certification for the lighting. And the reason for that requirement is that there is a concern that in the pursuit of finding cheap options, there are some bulbs out there that are not safe. So we want to make sure that the bulbs being used have been certified as safe either by the governing body in the United States or the governing body in Canada. So who can sign these letters? Again, this is covered in the regulations, but just to provide additional information. For most, it is going to be a licensed professional engineer or a licensed registered architect. For identified smaller operators or operators who persuade us that they need this additional consideration as part of a waiver process, they can use a certified energy auditor or a certified energy manager. This is a lower cost alternative. I will note that regardless of which of these two categories you fall under, your HVAC and dehumidification system information is going to need to be done by a mechanical engineer or a professional engineer whose license covers mechanical engineering. With regard to horticultural lighting, there are two pathways to compliance. Originally, you may remember there was the wattage requirement. We have added an additional option in the hopes that compliance will become an easier pathway for some. And the second pathway is to do with set lists on the Design Light Consortium Horticultural Lighting Qualified Product List. So the list is available on a website, and the website will be in our guidance, as well as some helpful information provided from the Design Lights Consortium as to how to work their website. And big thanks to the Design Light Consortium for being so collaborative on this issue. So there's the list, and then there is a calculation about which of the products on these lists will be acceptable to the Commission. And again, Design Lights Consortium is working with us to make that easy to ascertain on their website. So in addition, or as an alternative to the energy compliance letter, if you are using renewable energy sources for 80% or more of your total on-site energy use, you would provide an energy compliance exemption letter, which would discuss what you are using as your energy source, and then document that remaining 20% or whatever percent, less than 20%, you are using from elsewhere. Here are some of the options for energy compliance exemption. These are provided under Massachusetts law, and we provide links so that folks can go look at the laws in particular that describe these systems. And then we come to the renewal requirements. Part of the renewal requirements is going to be energy, water, and other metric reporting through something called the Cannabis Power Score. And I'm going to embarrass someone present here. Sam Milton, if you could stand up. Sam is one of the minds behind the Cannabis Power Score, and I would just ask that if you are interested in learning more about the Cannabis Power Score, either for yourself or for clients, please touch base with Sam, as he will do a much better job explaining the Cannabis Power Score than I ever could. So I highly recommend that, but it is an easy way for someone to upload information into this third-party software and generate a report that will tell us how efficient your grow is, and then maybe prompt you to take some steps to make it even more efficient. In addition, You will need to update anything that's changed in that energy compliance or energy compliance exemption letter that you have filed as part of your architectural review, if necessary, if you have a change. And that is it.
Wow. Thank you very much, Commissioner Doyle. Again, my appreciation is true for, I'm sure, the rest of the commission for your leadership and energy on this. Are there questions or comments, or do you want to pile on my lauding of Commissioner Doyle's virtues?
Please don't.
Just lots of accolades.
Any other questions or comments? Thank
right.
you very much, Commissioner Doyle.
You're
Dr. Johnson, do we have everybody here that we need for the next agenda item?
Mr. Chairman,
Yes.
do you need to adopt the guidance?
I guess we
document?
probably do need it.
Oh,
Thank you very much for that catch. Appreciate it. I was too busy singing her virtues.
I was too busy fawning in the praise.
Thank you. Can I have a motion to adopt the guidance? Thank you. Can I have a second? All in favor?
Aye.
Let the record show that the Commission unanimously approved the guidance proposed by Commissioner Doyle. Thank you very much. Thank you, Mr. Executive Director, for catching that. Dr. Johnson, are you introducing the next topic and our guests? Great. Well, first of all, thank you, Dr. Giesler and Dr. Whitehill, for being here today. I'll let Julie talk about your background and what you're going to be covering. But thank you very much for your help, both on this project as well as your participation today. Dr. Johnson.
Thank you, Chairman. As we continue the important work of research at the Commission and think strategically about how to maximize resources to fulfill the required and pretty robust Chapter 55 research agenda in forthcoming years, the Research Department procured a State of the Data project. This project comprehensively assessed the scope of the data and data sets that are collected and maintained by Massachusetts state agencies, federal agencies, or that are commercially available and relevant to evaluating the impact of legalization in the Commonwealth with respect to cannabis use behavior and perceptions, public health and healthcare, public safety, criminal justice, education, economics, and environment. So with that, I'm happy to introduce Drs. Jennifer Whitehill and Kimberly Geschler, who will be presenting this research report. Dr. Jennifer Whitehill is an assistant professor in the Department of Health Promotion and Policy at the University of Massachusetts Amherst. She is injury prevention researcher who studies cannabis policy and injury outcomes. Dr. Kimberly Geschler is an assistant professor of health policy and management at the University of Massachusetts School of Public Health and Health Sciences. She is a health economist and health services researcher, and her research focuses on access and care quality for vulnerable populations. Thank you.
Thank you, Dr. Johnson.
Does that work okay? All right.
I think, yeah, just be a little closer to it if you could, please.
Thank you, Dr. Johnson.
Can we hear her in the back? Go ahead. Thank you.
That's all right. Thank you, Dr. Johnson, Director Collins, Chairman Hoffman, Commissioners Title, Flanagan, Doyle, and McBride for your time and attention this afternoon. My team has worked in collaboration with the Commission's Research Department, and we are pleased to present our special report entitled Evaluating the Impact of Cannabis Legalization in Massachusetts, State of the Data. I'll start with this text from Chapter 55, Section 17A of the 2017 Act to Ensure Safe Access to Marijuana. It outlines the research agenda to be undertaken by the Cannabis Control Commission. The Commission's Research Department has previously presented and released analyses and findings related to several of the areas, but also has noted the extent and comprehensiveness of available data in all of those areas was unknown. My team collaborated with Dr. Johnson and her team to identify and assess data sources available in the Commonwealth that can be used towards fulfillment of the enumerated items in the research agenda. Additional topics were added in addition to what's in 17A. Our contract also included supporting the research department in procuring several data sources for analysis. I also want to talk about terminology for a minute for the report and in this presentation. We will use the word cannabis when referring to products derived from the cannabis plant. However, the word marijuana is used in legislation, in survey items, and in some data sources, so we will use that term when quoting from legislation or surveys. Here you see the overall structure of our report. This presentation will generally follow the same format. First, we will describe the purpose and methods used. Then the bulk of the report consists of 9 sections. 8 sections address a topic included in the Section 17A research mandate. We also included a section on data for monitoring energy use related to cannabis cultivation to support the Commission's fulfillment of Chapter 55, Section 78A and B regarding energy standards and the working group recommendations. We end with our conclusions regarding the overall state of the data and next steps needed that would help the Commission to best fulfill its research mandate and ensure that we have the best evidence on which to make ongoing regulatory decisions. This slide summarizes our purpose. We sought to help inform the Commission by identifying relevant sources of cannabis-related data from government and publicly available sources, describing key limitations, and raising considerations and suggestions for additional data collection that may be needed. There were 3 main steps to our process. The first was data identification. To do this, we reviewed government reports and websites and the peer-reviewed literature. We drew upon our academic expertise, and we contacted relevant government agencies to ask about whether they maintain data relevant to our purpose. The second step was data assessment. For each potentially useful data source, we determined its utility for monitoring cannabis-related trends. Specifically, we evaluated the extent to which the data is representative of the Massachusetts population. We assessed whether cannabis-related measures were present in the data and any limitations to those measures. We determined how far back in time the relevant data go, and we identified the process and any associated costs for obtaining the data. And the final step was reporting, which involved synthesizing the information and summarizing the data sources, limitations, and considerations in our report that we are presenting to you now. I'm going to turn it over to Dr. Geisler to present the first 2 sections of the report.
Thank you. The first area we assessed was the patterns of use, methods of consumption, sources of purchase, and general perceptions of marijuana. The law describes 3 population groups of interest, so we focused on these: minors, particularly adolescents, college and university students, and adults. We judged survey data to be the best type of existing data for monitoring cannabis use, patterns, and perceptions over time. We identified 7 surveys that may be useful in this area. 3 were national surveys with an indicator that allows Massachusetts estimates to be created. And for our purposes, we define national surveys as ones where Massachusetts can be compared to other states or the nation on the specific items of interest. There were also 4 surveys collected by Massachusetts agencies that are of interest. The specific survey data that can be used in this area are shown here, although we will not describe each in detail. More data are available to measure the prevalence of cannabis use, but methods of use and other agenda items are less available in survey data over time. The overall takeaway is that no one data source addresses all of the research agenda items in this area. A combination of sources will need to be analyzed to address all of the agenda items. The Massachusetts Marijuana Baseline Health Study is a particularly informative source on some questions that are not addressed in other surveys, but was a one-time survey and is not an ongoing source of data over time. As these surveys often contain sensitive information, using many of them requires an application process and expertise in the use and interpretation of results. We identified several limitations to the data in this area. They are listed here. I'll highlight a few now and mention a few others on the next slide. First, we note that the national surveys generally do not allow estimation for smaller geographic areas such as counties. This can be a problem even in state surveys. Second, Massachusetts does not have an ongoing survey that assesses modes of cannabis consumption, such as smoking, vaping, and consuming edibles. Third, existing population-based surveys do not distinguish between CBD and THC products. Our overall assessment of the data in the area of cannabis use patterns and perceptions is that cannabis use, age of first use, and perceptions of use can be reasonably well measured for the 3 populations of interest: youth, college students, and adult cohorts. However, there remain key limitations of the data in terms of the timing of data availability, the ability to use these data sources to examine specific subpopulations of interest, for example, populations living near dispensaries or pregnant women, and in measuring all research agenda items in this area. So our key considerations in this area relate to collecting additional data. Potential data collection efforts that could be particularly efficient include an extension of the Massachusetts Marijuana Baseline Health Study and/or adding additional questions to existing surveys conducted jointly by state and federal agencies. These considerations are in line with what other states with legal cannabis have done to improve their ability to monitor impacts of legalization. As there are a large number of complex surveys in this area that will need to be used to monitor all of the agenda items for each population, I'll use this opportunity to point out the need to engage external experts in the use of these data sources. The next area that we examined was data pertaining to hospitalizations and use of healthcare services related to cannabis. In the area of healthcare utilization and the impact on the state health system, we identified and assessed both survey data and administrative data. Administrative data are those data collected as part of existing processes such as hospital records and health insurance claims. We identified 5 surveys that asked items about both cannabis and healthcare utilization. Some of these surveys contain specific questions about cannabis-related healthcare services use, while other surveys allow us to identify cannabis users and non-users and compare healthcare utilization across those groups. There were 2 national surveys with an indicator for Massachusetts, and then 3 Massachusetts-specific surveys. In terms of administrative data, Massachusetts has a large number of sources. We identified 13 administrative data sets. 6 of these are national data sets in which we can identify Massachusetts, and 7 are Massachusetts-specific data sets. So this is a complete list of the data sources, but we'll only highlight the most important parts. In terms of survey data, some of the same surveys that assess cannabis use are relevant here. And then in terms of the administrative data, there are a number of different administrative data sources that address different ways that cannabis use could be related to health services. So generally in these data, one must use cannabis-related diagnosis codes to identify health services use that's related to cannabis, and in particular, cannabis use disorder. These data sources can be used to assess different kinds of healthcare use and health outcomes, including emergency department, trauma center, and hospital visits, overall healthcare utilization, treatment for substance use disorder, and information about poisonings. Some of these data sets are relatively unique to Massachusetts and allow for monitoring a broad set of healthcare utilization indicators in a larger population. So one data source of particular note is the Massachusetts Public Health Data Warehouse, which has been constructed by the Massachusetts Department of Public Health. The Public Health Data Warehouse combines a large number of government data sources at the person level. Right now, this is primarily used for opioid-related research and cannot be used for cannabis research, but with adequate partnerships may be a potentially powerful data source in the future. The main limitations of these data to evaluate the Commission's research agenda items in this area are, first, small sample sizes in survey data useful for capturing self-reported hospital and emergency department use for cannabis. 2, changes in the usefulness of administrative data sources over time due to undercounting of cannabis-related encounters and regulatory changes that may coincide with cannabis legalization in Massachusetts. So understanding these limitations for the use of the data are important in selecting and analyzing data. Our overall assessment of the data available to address this agenda item is that Massachusetts is actually doing quite well in available data. There are a large number of data sources, each of which is extremely complex, and it's likely necessary to use multiple sources as each is measuring different outcomes and populations of interest. It takes significant time, expertise, and research infrastructure to use these data well. This expertise is necessary both for the procurement and data preparation processes, as well as in the use of the data to ensure that the estimates produced are correct interpretations of the data. Thus, external partnerships are likely to be necessary to ensure that the Commission can fulfill its research agenda in this area. Our key considerations for the Commission are related to steps that will ensure data in this area can be obtained and analyzed to draw reliable conclusions. So we suggest that the Commonwealth consider conducting new primary data collection to better understand clinician testing and coding of cannabis-related behaviors, and to determine the extent to which cannabis use disorder claims may be redacted in available administrative data. Additionally, the Commission may want to explore collaborative agreements that will allow necessary expertise from academic, government, or other partners to support rigorous research using these complex data sources. So thank you, and I'll now turn things back over to Dr. Whitehill for the remainder of the findings.
The next area that we'll talk about from the excuse me, research agenda pertains to incidents of impaired driving. Before describing our findings in this area, I want to make an important note about our methods for this section that is also a key limitation. As I think many of you know, measurement of driving impairment due to cannabis in non-experimental settings is an ongoing methodological challenge. The presence of THC alone in a driver's blood, oral fluid, or urine does not mean that the person was impaired by the psychoactive effects of cannabis at the time of driving. In recognition of this challenge, it is more accurate to say that we assess the availability of data that could address cannabis exposure before driving in the data sources that utilize some kind of biological measurement. Survey data, in contrast, typically has questions about whether or not someone has driven under the influence of cannabis, which is subject to individual interpretations and may not be the same thing as being impaired. In this area, we included only data sources that allow identification of cannabis exposure or use in a person who was involved in a driving episode or in a crash. We identified 3 administrative data sets and 5 surveys that may be useful. Here is a listing of the data sources we deemed relevant here. We do not have time to discuss each one, but I will summarize by saying there are administrative data sets that could be examined to identify incidents of exposure among cannabis exposure among drivers, and those include a national fatal crash data set. This contains information on whether drivers in fatal crashes tested positive for THC or other cannabinoids. The Massachusetts Trauma Registry has information on persons with severe injury, including drug screening results and diagnosis codes. And Massachusetts Drug Recognition Expert Data, or DRE data, covers law enforcement assessment when drug-impaired driving was suspected and a DRE evaluation was conducted. We also found 5 surveys with questions pertaining to cannabis use in driving. There are many limitations in this area, and I'll mention a few key ones. In addition to the big one we already mentioned regarding testing for cannabinoids and indicating impairment. First, even though we have good database for all fatal crashes, only deceased drivers are tested at high rates. Drivers who survive a crash that kills someone else have low testing rates that preclude reliable estimation. Second, in the trauma registry, positive drug screening results may predominantly come from urine drug screening, which indicates cannabis exposure in approximately the past month. Third, the forms used by police in Massachusetts to report crashes do not collect information specific to cannabis. Because of that, we did not list them as a data source for monitoring cannabis and driving, although we describe them a bit in the report. Our overall assessment is that incidents of cannabis impaired driving cannot be well tracked in Massachusetts at present. We are limited to measuring cannabis exposure in drivers killed in fatal crashes, drivers seriously injured and treated as trauma patients, drivers evaluated by drug recognition experts. There are also several surveys that assess self-reported driving under the influence of cannabis, and each of these data sources has some significant limitations. So in this area, many of the steps needed to address those data limitations would require action by the legislature or other government agencies. But from the perspective of the Commission's research mandate and limitations notwithstanding, we suggest that the Commonwealth monitor the presence of THC in crash-injured drivers for both fatal and non-fatal collisions, consider changing police crash report forms to include cannabis-specific items, and consider changing how OUI data are tracked to allow monitoring of OUI cannabis incidents. We encourage the Commonwealth to consider survey data collection and to invest in research towards having reliable tests or combination of tests for impairment. We also refer interested individuals to the report released by the Commission's Research Department in this topic in January 2019. The next area of the research agenda relates to assessing ownership and employment trends in the cannabis industry and examining participation by racial, ethnic, and socioeconomic subgroups, as well as identifying barriers to industry participation, which could be expected or experienced barriers. The Commission has been consistent in adhering to the mission of creating a robust industry, including active provisions to facilitate participation by minorities, women, and veterans. These public meetings continue to provide transparency on this process by presenting the varying demographics of the nascent and growing industry. For the sake of being thorough in our reporting of the required research areas, and at the risk of telling the commissioners and commission staff what you already know, I'll quickly review what is collected on ownership and employment trends. The data collected by the Commission via the Mass CIP portal can address agenda items related to business ownership and workforce. This will be presented next month in a baseline industry report. Thus, I won't delve into details here. Additionally, the Commission is assessing experienced or projected barriers to entering the cannabis industry, which will be presented more fully in a 2020 report. Although data is being collected or planned in this area, there are some potential limitations, such as the study on barriers to entry having challenges with participant recruitment of a diverse sample of current and potential business applicants. Providing monetary compensation for participants, a common practice in research, can help address recruitment and retention challenges. Next steps would include focusing on priority groups such as social equity applicants who can best speak to the lived experiences.
Bless you.
Chapter 55 also requires the research agenda to include a market analysis examining the expansion or contraction of the illicit marketplace and the expansion or contraction of the legal marketplace. The Commission compiles data on the legal cannabis market via the seed-to-sale tracking system that includes agent registration, applications and licensing, and sales and product distribution. It is difficult for research to accurately assess the scope of the illicit market. Some of the key data sources as used by researchers in this area include law enforcement data on seizures of cannabis and surveys that ask about cannabis use behavior and what individuals pay for cannabis products, as well as cannabis pricing websites. All of these data have notable limitations, and this is an area of active ongoing research, especially in other states that have legalized cannabis for adult use. There are also companies that provide proprietary business analytics for the cannabis industry. To summarize some limitations and key considerations in this area, we note that the Commission collects detailed supply-side information on the legal cannabis market. Some existing demand-side information can come from crowdsourcing and private firms, but the reliability of those data are unknown at present. In the future, demand-based information will become available through a partnership on the International Cannabis Study, which assesses varying impacts in both U.S. and Canadian samples. This study will provide data on where survey participants are accessing their products. We suggest the Commission consider partnering with external researchers and collaborators to undertake a robust market study. Another area of the research agenda requires a compilation of data on the number of incidents of discipline in schools, including suspensions or expulsions resulting from marijuana use or possession of marijuana or marijuana products. The Massachusetts Department of Elementary and Secondary Education collects discipline data at the school level, including marijuana possession and marijuana use. Data includes the disciplinary action taken, such as a school suspension. With a proper data use application and agreement, individual level data, including demographic and geographic information, can be accessed. Procurement of school data will require an institutional review board and oversight, so we suggest that the Commission establish a collaboration towards that end. The legislation also requires a compilation of data on the number of civil penalties, arrests, prosecutions, incarcerations, and sanctions imposed for violations of Chapter 94C for possession, distribution, or trafficking of marijuana and marijuana products, as well as specific demographic factors for the persons charged. Unfortunately, a lot of this data isn't systematically collected, and if collected, it may not be accessible or comparable across data collection mechanisms. So to set the stage in this area, I want to borrow a slide that you may be familiar with from past presentations by the Commission's Research Department. For more on this topic, please see their April 2019 report. But I will briefly review some of the data sources in this area that were previously analyzed by the Commission and mention some additional sources. As background then, and as you know, Chapter 94C is a Massachusetts law that categorizes drugs, drug violations, and the punishments for violations. Here you see an overview of the types of offenses included. Chapter 94C categorizes cannabis as a Class D drug and outlines limits and consequences for trafficking, distribution, as well as civil and criminal possession. Keeping that in mind, we examined the available data and found that all of the data used to monitor criminal justice encounters related to Chapter 94C violations are administrative data compiled by law enforcement for their own purposes. The data are generally categorized by the offense, which means that offenses related to distribution of different drugs within Class D are grouped together. This is a pervasive issue throughout the data from the criminal justice system, but that said, we identified one national data set and 4 state-level data sources. We also note that municipal-level law enforcement data are relevant here, but it was beyond the scope of our project to contact individual cities and towns. So here we summarize a few types of data available in this area. Arrests are tracked in a national law enforcement database maintained by the FBI called NIBRS. NIBRS data were previously analyzed and reported on by the Commission's Research Department. Most municipalities report their data to NIBRS with some notable exceptions, including the Boston Police Department. The state police also compile information on arrests. Sentencing information is compiled by the Massachusetts Executive Office of the Trial Court, and the Massachusetts Department of Correction maintains information on incarcerations, including length of sentences, length of time served, conditions of release, such as being released on parole or probation. It is important to note when thinking about this incarceration data that because of changes in cannabis policy, many individuals with cannabis-related sentences would serve time in county-level houses of correction, which means each county has its own data and own data access process. In terms of limitations, as noted previously, Class D offenses group together cannabis and several other drugs, so manual case review may be necessary to understand cannabis-specific offenses. And there is no centralized data source for citations or fines paid for cannabis possession civil offenses. In summary, arrest sentences and incarceration related to cannabis are tracked by various agencies in Massachusetts. The way that cannabis is classified with other drugs is a challenge. In this area, we suggest partnership with state agencies to access data, and we also suggest that the Commission, in partnership with the Executive Office of Public Safety and Security, consider a mechanism to monitor civil penalties for cannabis possession, including tracking demographic information. The final aspect of the Chapter 55 agenda that we'll briefly touch upon here is the requirement to monitor the economic and fiscal impacts of cannabis legalization. Economic evaluation requires highly specialized research skills, and assessment of the available data is a part of actually building a model, which is out of the scope for this project. Many data sources are brought together for such a model. All of the sections of this report can help inform such an analysis by enumerating many data sources and their limitations. We do wish to highlight just a few things in terms of history, limitations, and considerations. First, the Marijuana Baseline Health Study included a model of state-level economic impacts, but a new economic model incorporating updated information will be necessary now that retail sales have begun. Second, data on the municipal level may be more difficult to collect. We also considered available data on energy due to the Commission's interest in assessing the Commonwealth's ability to meet Chapter 55, Section 78. While we focused on electricity, this section of the law is much broader and merits additional attention. We identified 4 sources of electricity data, but our assessment revealed that none of these sources in their current form are granular enough to assess the impacts of legalization on energy use. Data would need to come from electricity suppliers. In Massachusetts, there are 4 electric companies and 40 municipal light plants. These are regulated differently and thus have different potential avenues for making data available. Overall, we were not able to find any source of data that would be usable in its current form. The real issue with each of the data sources in the energy sector is that they do not contain data at a local level, and state-level data are likely not to be granular enough to detect potential changes from the cannabis industry. Our primary suggestion is in line with what the Commissioner, with Commissioner Doyle's guidance, is already beginning to implement, which is to consider the collection of electricity use information from legal cultivators. This has evolved during our time of preparing the report, but our understanding is that the most recently updated regulations will require submission of electricity and water usage data to the Commission upon license renewal. This will likely be a very useful data source in the future. So, to wrap up and summarize our findings across the many domains for which we evaluated the available data, we provide this summary chart rating each area based on the extent to which data exists and is readily available to address the domain. We conclude that the available data allows some of the Chapter 55 research agenda areas to be readily assessed, but insufficient data exists to address others. Some additional data collection and endeavors to empirically assess the quality of existing data will be needed to fulfill the research agenda requirements. Key areas of strength are ownership and employment trends and cannabis markets. Areas of significant challenge include cannabis-impaired driving, criminal justice encounters, and some important aspects of cannabis use, such as mode of use. Regulatory changes about required reporting of energy use by cannabis cultivators may address the present lack of data in that area. So looking across the domains and at the larger picture, we find overall that the Commission has a large amount of data collection and analysis that would be needed in order to fulfill the research agenda, and will likely need to develop appropriate partnerships to carry out that work. These include partnership with state agencies to access data and external partnerships to access research infrastructure. Both new data collection and empirical assessment of data limitations in existing data is suggested. We also suggest that the legislature consider revising the annual reporting interval to a timeframe that allows the conduct of rigorous research. A research roadmap could be developed by the Commission to lay out what timeline is appropriate and feasible for different areas. We point out that areas that require new research take longer to complete. Other states with legal cannabis use cannabis revenue to support innovative and important research related to cannabis and the many existing basic science, applied science, and policy impact questions that are presently unanswered. Massachusetts has undertaken some regulatory approaches that are novel. If the research department and partners work in concert with regulators, regulatory changes can be harnessed as so-called natural experiments that would allow evaluation and learning about the impact of such policy changes. Such undertakings could help Massachusetts maximize the benefits of this policy, minimize burdens, and be a leader among states with legal cannabis. Thank you so much for your time and attention. We're happy to take a few questions.
Thank you, Dr. Giesler and Dr. Whitehill. That was, I found extraordinarily informative, so thank you very much. I do have a few questions, but let me defer to my fellow commissioners. Commissioner Flanagan?
Mr. Chairman, thank you. Thank you, Dr. Whitehill. It's good to see you again. Thanks for
Did you
coming out here to
you
Boston.
teach her everything she knows?
No. Try. And Dr. Gessler, thank you so much for being a part of this. I think it's always important when we can partner with our public universities, especially to talk about data and the health effects of what we have here for legalization. And Dr. Whitehill, you and I have talked about this for a couple of years now, is that how do we get to where we want to be with data? And I think the reality is that due to the way that we came to legalization, the laws and didn't really catch up to what we needed to collect for data. Fortunately for us, Representative Hannah Kane from Shrewsbury filed a couple of pieces of legislation to help address that and to really ask for certain data. But one of the bigger questions that I have for you is, in the report, you talk about some of the limitations with the actual data being presented, collected. When you looked at the national surveys, were you able to gauge at all how the other states with legalized marijuana are doing, or how far they've come from pre and post legalization with their data collection, and are we on par with that?
So let me just repeat back to you to make sure that I understand the question. It was out of the scope of this project to look at the potential differences in what's happening in other states, but we did look at, and from some outside expertise, some familiarity with what other states have done to, for example, add some questions to some of their ongoing big public health surveys, specifically to be able to assess certain cannabis-related indicators. So I could certainly provide some follow-up information about that. This assessment was limited to what do we have here in Massachusetts, but yeah, I'd be happy to follow up a little bit if you want some more information about, for example, what Colorado has done or some of the other states.
No, I appreciate that. I think it's important for me, as a public health appointee, to see where we were and how far we've come in data collection. And I'm interested about the states that had come before us. Was there actions that had to be taken for them to really increase their data collections, and in what areas they did? One of the other questions I have, and I promise I won't go through all these tabs, because
I was worried about that for a second.
I will just call you.
Not only the test, but all the color coding.
Listen, I color-coded my questions, okay? So in your recommendations, there's certainly some action items that can be taken here with the commission. I mean, there's collaborations that obviously can be looked into and hopefully created through this. And you also have legislative recommendations too with regards to changing the law. Have you ever had conversations with legislators or with someone in authority to actually change the laws and to sort of put this on the forefront, or is this the first time?
I have not had those conversations with legislators personally. I think that would be an interesting next step, and something that I'm aware that some of the commissioners have been involved in certain efforts to revise some of the laws, but that certainly could be a next step.
Okay, I can help you. My one last question is, when you talk about the effects on our health system, and you have the trauma report and you have the ED visits report, the one thing that I didn't see there, and it literally could be because we don't track it, is there any data that talks about 911 calls? Because we all know that when the ambulance gets there, they have a right of refusal. They don't need to be transported to a hospital, but they might have felt so incapacitated or so endangered that they called 911. Is that something that you see as being tracked? Because I think it's important to note that as a trend of, you know, if you feel you're in trouble and you can call 911, but when they get there, you might say, yeah, you know, I overreacted or I feel better, and you'll never end up on that ED report.
Yeah, I think that's a great point. I'm just going to confer here with my other expert in this area. We're going to say that we're a little familiar with the ambulance data that we have, but we'd be happy to get back to you about this particular piece of it, because I agree that's important, and I don't want to misspeak.
No, and I appreciate that, because I think from my perspective, the reason why I ask is that we know that all patients don't end up at an emergency room. And so I think it's important for us to understand the number of patients that do versus the number of patients that feel they may need that level of care. Because for me, and this is just because of, I grew up in the EMS world, that's a strain on our health system as well. So getting the ambulance to your house or wherever you are is a use of resources. So I'd be interested to see, and I don't know if OEMS even collects that data at this point on their matrix reports.
Yeah, I was going to say, we are familiar with Matrix, which is the ambulance data set here in the Commonwealth, and so I'm not 100% sure what happens with refusals. And I also know that the national standards for how ambulance data is reported have been evolving over time, and I believe moving to integrate more information related to drugs. But as you know, in certain areas, sometimes all drugs are lumped together, and so you can't necessarily separate out what was a cannabis-related call from something else. So I think it's an important thing to keep looking at.
Yeah, and about a year ago, I talked to OEMS with regards to the fact that they have sort of a Narcan/opiate piece on the matrix report, but there's nothing else. And given the fact that there's a multitude of drugs, not just cannabis, it would be interesting to see them incorporate that when they redo their matrix report. So, but thank you so much. I really appreciate all your work. I won't take up any more time, Mr. Chairman, I promise.
No, I think this is an incredibly important topic, so I'm certainly not trying to cut anybody, including yourself, short.
I can go visit Dr. Whitehill.
Again, I'm going to hold my questions till last, but any other questions or comments? Commissioner Doyle?
Thank you, Mr. Chairman. Again, thank you, and thank you for your tolerance and understanding of my questions previously on all things energy and environmental. And I really do appreciate you highlighting what we're trying to do on the collection of data that side. And I pledge to you my support in advocating for data collections, not only in that area, but in the other areas that you have highlighted in your report. Because I do agree it's difficult and frustrating, especially where the data is there but not centralized and accessible. So I support you, and thank you very much for your work on this.
Commissioner McBride?
And I'm just going to echo the appreciation of my colleagues. And I think that this, again, affirms what we learned from what Dr. Johnson presented earlier in the year, I think particularly as it pertains to issues like impaired driving, where there's this real huge gap in just information that's available. And so drawing conclusions without that information is very difficult to do one way or the other. And so driving towards a place where we can obtain that information and do it in a consistent way is extraordinarily important. And I think we have some opportunities now, but I think that that's going to be an ongoing process, and it's something that's critically important, because to make assertions that because the data isn't there, it shows one thing is very dangerous. I think also the other, it's really interesting because the two pieces that I have most interest in are the ones where there doesn't seem to be a lot of information available. The scale of the illicit market and trying to collect information there. And so I would be very interested in exploring a little bit more what our options are in trying to get our arms around what that market looks like. And I know that it's a place where other states who have gone before us have done work, but a lot of that work has been done fairly recently. And so it has taken them a while to get there. I don't want to wait too long for us to get there. I want to try to explore that now. So thank you.
Mr. Channel?
Thank you so much, doctors. Your expertise and your objectivity and all of the work that you put in really comes across and shines, so I appreciate it very much. I have two questions, actually two questions on ownership trends and then one question on emergency room data. So it was great to see on ownership trends that it was green, and I really appreciate the research team's work on that. Especially given that that's probably out of all the areas, the one that we have looked at first, so people are really looking to our data on it. So you said that monetary compensation would be helpful. Can the research department put together what a standard budget would be for that? And are we discussing that in the context of the barriers to entry study?
Yes, for certain survey procurements and focus groups, monetary compensation, such as we did in the public awareness campaign, is normal for adequate recruitment and retention of participants. And this is especially important for certain participants that we are looking for in this instance, which is underserved or cohorts disproportionately impacted by cannabis prohibition. This is an ongoing conversation internally, and I would definitely be happy to talk about it, but yes, we are having those conversations, so to be further discussed.
Thank you. And then my other question is, this is kind of a dumb question, but in the report it says that the demographic data is limited because it's self-identified. I assume there's no feasible alternative to that, but just making sure.
You're thinking about that in terms of the industry participation data? Yes.
Okay. And then, so in terms of emergency room data, so forgive me as one of the lawyers, I don't have very sophisticated vocabulary here, but in the most ordinary terms that you can explain it, we are obviously very concerned about accidental ingestion by children, and we keep seeing reports that those incidents are increasing. But it doesn't seem like it's very easy to get more information about what products are associated with that accidental ingestion. So if someone gave you a magic wand and you could get that information, what would it look like?
I might suggest looking at a recent paper that I published, which is like, I totally wasn't planning for this to be an opportunity for self-promotion.
I planted that.
That's fine.
I do feel like maybe that was a little bit of a setup. And so let me think about this. Yes, the data that comes through the Regional Poison Center does, now the poison data allows for looking at product type, so we can differentiate whether it was an edible product or there's a whole lot of codes in that data, an extract-related concentrate or extract-related product, dried plant or plant material. So that is there. If the interest is in something even more specific than that, like specifically which brand or which product, I am not aware that that is being tracked, but I have had some conversations with my colleagues in emergency medicine about ways to potentially add capture of that data to some different existing databases. It seems like in this day and age, technological capabilities would exist to take a picture of a label or probe a little bit more deeply, but I think that would be something that that needs to be set up to make that happen. It doesn't exist in the current areas, but it's something that potentially in partnership with the hospitals or certainly the Poison Center could be thought about asking for cannabis codes.
So I didn't actually realize you were an expert on it. That was organic.
Sure. That wasn't the pre-planned setup?
I know, it was almost too perfect. So just the category of edible, I feel like for our purposes wouldn't be very helpful if we wanted to know like flavors or shapes or something about it that was attractive. So the conversations to track those attributes are in progress?
Yeah, and I think there have been some conversations potentially between some folks here at the commission and some emergency department researchers, and sort of looking around because I was not actually on that phone call, but it's something that could be pursued.
Thank you.
And I agree that that would be great.
I'd like to just jump in there, and I think that this is an opportunity, or one of the things that we have talked about in the past is creating a database. That, you know, we've talked about this a few times, right, and trying to get that together so that it may not be that we have to add something to some other database. We may have a database that we eventually can make available to a number of different entities, hospitals and others, and be collaborating with them, and they can be using the information that we are sourcing and communicating with us about what they're seeing.
Thanks.
That's my plug.
Thank you. Anything else for? I have a question around economic modeling, which you mentioned that might be actually more directly addressed to Dr. Johnson, or might be better addressed offline. I'm fine with that. But piling on to what Commissioner McBride said about her interest in the illicit market, I have the same interest and the same sense of urgency that she has. But I also have a strong interest in trying to model and understand how we can impact the size of the illicit market. And obviously the number of stores that we open is part of it, but I'm thinking about things like pricing, I'm thinking about things like geographic location of stores. So you mentioned two things that I just wanted to understand a little better. One was the international cannabis study, which I'm sorry, I would love some more detail on. And then, but you made several references to economic modeling, and I'm wondering if those references that you made to economic modeling consider or include the kind of ability that I want. Because I actually do think that we have the ability to impact the illicit market based upon policy decisions we make, and I really think it's important for us to understand that. So, I don't know if that's, again, for Dr. Johnson or for Dr. Whitehall.
I guess what I can add, and I do think it would be nice for Dr. Johnson to talk a little bit more about the specific study, the international cannabis study, but there are some other states that, as Commissioner McBride mentioned, could be looked to for examples of how these data on the illicit market can be obtained. So that's certainly a resource that we could follow up with to channel your way.
Again, I'm certainly interested in, that's what I was piling on and agreeing with Commissioner McBride about how to obtain data, but I'm also very interested in what we can do with that data. So maybe that's for a different conversation, because it's not about data sources, it's about what you do with data in terms of modeling and understanding the impact. Dr. Johnson, I don't know if you have any thoughts on that.
Yeah,
And
so
again, we can talk offline if that's more appropriate.
whatever you want.
No, just give me a quick response. We can follow up later.
Yeah, so the illicit market kind of configures a triangulation of multiple data sources. Because it is illicit, it's not something that is empirically assessed. We are contracting with Dr. Hammond, who is the principal investigator of an international cannabis study. He's a well-known researcher with tobacco and is edging into the cannabis field. He actually started a research study that in 2018, so we have Wave 2018, and now we're getting Wave 2019. And one of those, some of those data questions, measures we are specifically interested in, because it asks questions about participants and how they're accessing their data. And that's a common indicator measure that is systematically excluded from a lot of our systematic data collections. And it is really important for both the assessment of the illicit market and looking at our own trajectory of our illicit market and our industry. Next month, hopefully next month, knock on not wood, the industry report will be coming out, and we did again, a comprehensive review of the literature, both peer and gray literature, about how other researchers have done this and kind of this illicit versus licit market analyses, but it does include more modeling and more in-depth modeling, economic projections. Yes.
Okay, thank you. Other questions?
Mr. Chairman, I want to thank Samantha, who's in the back, who
Sure.
Isn't sitting up front, but does a lot of work for the research department. And really my appreciation for, Dr. Whitehill, Dr. Gessler, and our research team, because I think this is an important place to start, and this sort of helps us get answers to some of the questions that we have moving forward when it comes to policy discussions. So we really appreciate the hard work and that you're digging deeply into this.
Thank you, Doctor, and Doctor. Thank you very much. And Samantha, thank you as well. Really appreciate this. Could I get the clicker back, please? I'm sorry. I'm really possessive about this clicker. It makes me very insecure when I don't have it in my hand. Thank you. We have two remaining agenda items. They are actually both related, and so I'm going to actually provide a little context before we get into them. These are both related to a performance management process that we have executed for the executive director, and it has three pieces, in my opinion, to it. Two are being discussed today, but I want to make sure that everybody had the complete context. One is, as all employees, we believe that everybody should have a regular performance evaluation, performance review. With the guidance of the general counsel, I made the decision that we would not conduct Sean's performance review in public. We don't require that for any other employee. I think it was bad enough that we actually interviewed Sean in public, and I think it was even worse when we discussed strengths and weaknesses of our three final candidates in public. So with the guidance of the general counsel, we designed and executed a process to conduct it in private. What that means explicitly is that I sought input from Sean's direct reports as well as the other commissioners. I did not share that input with anybody else, but I consolidated it and without attribution sat down with Sean and went through the input from all those people in a private session, and that's going to stay private. But there are two other parts to the performance management process that I believe, well, I don't believe, the fact is they have to be public. One is going forward, and this in a perfect world would have been placed last year so that we could have used it for the performance review that I just did with Sean. But going forward, we absolutely want to have it in place, which is a set of agreed upon goals for the executive director that are discussed, voted on, and approved by the entire commission. That will be used as the basis for Sean's performance review at the end of this fiscal year. So the process that we used there was that Sean and I worked back and forth on a set of goals. It is explicitly a draft, and it's explicitly a draft because it needs to be discussed in public and voted on by the commission, which is the next agenda item. The final agenda item is also part of the performance management process, which is to discuss compensation adjustment, if appropriate, and then a change to any other terms of employment for Sean as part of this performance management process. So we'll get to that after the discussion of goals. But executive compensation for public officials is public, obviously, so it needs to be voted upon in public. That being said, I'd like to move to the first of these last two agenda items, which is the executive director goals. Again, first of all, my apologies that it's so small, and so hopefully people can read the print. Once again, Sean and I think, went back and forth 2 or 3 times on this. I'm comfortable with it. I won't speak for the executive director, but I'm comfortable with these, but I am certainly not comfortable going forward without discussion and a vote of the commission. So I circulated these earlier. I would very much appreciate thoughts, comments, suggested changes to this. And I'm sorry, let me leave it there. Commissioner Flanagan, were you? I don't need to put you on the spot.
Okay. I think first and foremost, what I would like to do is, while we talk about the goals, and some of these are pretty straightforward, and express my appreciation for the work that's happened so far. I think the fact that I'm about to have my 5th office in 2 years shows that we've gone from nothing to where we are going to be in a couple of weeks. And I think that along the way, a lot of these goals already had to be addressed, and a lot of them have been put into practice. I think there's, for me, when we talk about improving efficiency in the licensing process, to me that takes staff. And we cannot fit one more body upstairs on the 13th or 19th floor. So I think for some of these, while I will agree with some of them, I think they'll be better judged when we get to Worcester and we're settled. So I think that for me, I mean,
the intention is to make the judgment at the end of
right.
this fiscal year, so certainly not immediately. And
but I think for me, I think that judgment needs to start from today. I just think that you know, we're 2 years into this, and we probably should have done this last year, like you said. So I think overall I agree with these. I do think that some of them, for instance, our handbook needs to be done by a department, and that department needs to come through. And obviously Sean's oversight of that is going to be important, but I think this is a good place to start.
Thank you. Other comments or suggestions? And I'm also, you know, even though I was able to circulate these ahead of time, if there's more time required to think these through, we can come back again. But Commissioner McBride?
I'm just going to echo what Commissioner Flanagan said. A lot of these goals strike me as things that require a team effort. Now, understanding that, you know, we have a captain of the ship, but we also have several first mates, and everyone needs to be kind of pulling together. So I think that as far as, you know, goals for being able to efficiently, you know, delegate to those first mates those responsibilities and carry them forward, I think that that is, you know, a goal that is attainable. But I guess I want to make it clear in looking at these goals that these are I think in no way are these all to be shouldered. I want to make it very clear, and I think we all understand this. They're not all to be shouldered by our executive director, who has done the monumental task of getting this agency up and running, make sure that the trains are running on time every day, and brings his all every day he comes to this job. And also on days he doesn't come to his job, weekends, et cetera. So I guess I just want to, in looking at these, I think that these are goals that are important to put out there, but I'm going to echo a little bit of what Commissioner Flanagan said, in that you know, there are important pieces here that require a lot of people to come into the mix on this, and I just want to kind of make sure that we're remembering that as we're kind of trudging along. You know, there are other pieces that have to come into play here. It's not about just setting goals. We do need bodies, as Commissioner Flanagan said. We do need to be settled in a permanent space that provides us with a forum to be able to put all of this into play.
Okay, I thank you. I have a few things I'd like to say in response to that, and this is going to reflect. I apologize, but this is going to reflect my private sector experience probably more than my 2 years of government experience. One is obviously these require staff. Two is that I believe, and I hope the executive director would agree with this, that what should happen after we agree on whether these goals are a modified version of these goals, they should cascade down to Sean's direct reports and from there to the next level. Clearly, the purpose of starting at this executive director level is to say, we know the organization needs to support this. Now let's make these into goals that specifically address what people on the staff have to do. Third is, while there's no question that Sean needs additional help to do any of these things, at the end of the day, he is the executive director, and my private sector experience would say that if you're the CEO, you have goals, you can't do any, you know, it's even worse being a CEO than being an executive director. You can't do anything by yourself. You need staff, but that does not stop a board of directors from giving a CEO goals. So I think that these goals are important. I absolutely understand they need staff to implement them. I believe the best approach, in my opinion, is to use these to cascade down to the next level of staff. But yeah, I guess, and the final thing, and you know, I'm not going to put the executive director too much on the spot. More than he is right now. Well, I don't think he's on the spot at all right now. But in again my private sector experience, this process only works if the executive director or whomever the person we're talking about is, if they agree to the goals. So I would not want to say we're going to just put together a set of goals, whether these or others. This has got to be a collaborative process with Sean, where Sean says, yeah, I accept these goals. So I think he needs to have a say in this. I'm not going to put him on the spot right now and say, do you agree? But I think that before these get finalized, Sean has to be explicitly engaged in the process to say, I agree with these goals. So I don't know if that addresses the concerns that you and Commissioner Flanagan raised, but that's certainly the way I think about the concerns. Commissioner Title.
What a mortifying process. I'm so sorry. This is so ridiculous. I'm sorry we have to do this, but we have to do this. Okay, so process question. I don't understand, so I just want to clarify. Is Sean's input already reflected in the
Yes.
goals?
Yeah.
Oh, it is?
Yeah,
Okay.
Sean and I worked on this, I don't know, Sean, we went back and forth 2 or 3 times. So, yeah, but I'm not going to put him on the hook and say, do you agree with all these goals? But we worked on these. This is a mutual document. You can.
Is that coming next?
What?
I'm
No,
just
this
confused
is a
about like
mutually-
when
this is-
Sean's agreement to those goals
Yeah, this is
comes
mutually
in the
derived
process.
goals. Sean, why don't you comment on your perspective on this?
I appreciate the sympathy for the process. That said, oddly enough, and it really is just an odd coincidence, today marks my 2 years with the commission as far as starting. So
Applause allowed.
it's been a long 2 years.
It's been a long day.
Because I think we've been busy building something. So what I will say, though, is I do agree to these goals. The reason I agree to these goals is because I'm happy to be held to account for each aspect of this agency. And the reason I'm happy to be held to account is because of the team that we've built and the folks that I know will ultimately be responsible for execution. And I am happy to be held to account on behalf of our team, personally for myself, but also the fact that each of the various department heads and each of the employees that we've introduced over the course of those 2 years is the reason I'm happy to be held also to 10 goals is because of the quality of the team that we've built and their ability, I think, to meet a diverse array of objectives. But it also speaks to the diverse array of tasks that this agency needs to tackle. We have grown from the 5 cubicles in Ashburton to where we sit today versus where we'll sit in just a short amount of time. Each of these things, though, I think are important for the commission to continue to meet its objectives to the variety of constituencies. And to the earlier comments around improving efficiencies, I do think a lot of this will stem to, or will ultimately be accomplished through the addition of staff, but also a continued evaluation of our processes. And again, I think I'm happy to be held to account because of my confidence in the folks that I get to work with and their abilities and their skills. So I realize it is awkward, it's very strange, but I think also that I'd like to give them, the staff that I get to work with every day, more direction and more, I guess, to try to harness a lot of those tasks and challenges. So my intention with these goals really would be to then meet with them and say, these are now our goals.
Right.
And again, I intend to sit before you next year and be held accountable for these.
So I appreciate that. I just want to make one more comment, then I know you have quite a follow-up question. Again, I was going to say the real world, that's pejorative, in the world that I'm familiar with, more familiar with than the government. This is a working document. This is meant to be the basis for an ongoing dialogue between the commission and Sean during the course of the year, and for Sean with the rest of his staff during the course of the year. Circumstances change. And so, I'm not suggesting that willy-nilly we change goals partway through the year, but I am suggesting that we have an ongoing conversation. And if circumstances change and one of these either become unattainable or irrelevant, we certainly have the flexibility to have a conversation in public to do that. So I just want you to know that, at least in my perspective, this is meant to be a working document, but not something that we just change every week. Go ahead, Commissioner Tittle.
Thank you. I did want to make sure that input was there before I commented on the goals. I think the goals are completely consistent with what I hope to see and what I think the public would hold our staff accountable for. And also it reflects the shift as we move away from building the agency and getting physical space and creating foundations to now looking to improve on those foundations. I want to compliment the process because maybe it's because I'm from the private sector too, but I completely agree with everything that you said. And then on top of that, I appreciate just how awkward this process was to put together. And I think you did it just right.
Well, thank you. But I want to just make sure that General Counsel gets credit for helping me think that through.
Both of you. So yes, I agree that this should be made public once it's finalized, and that we should revisit it periodically, and especially a year, that these are just the right goals to come back to. So thank you.
Commissioner Towne. Other comments? Commissioner McBride?
I just have another, so
Pardon?
I want to keep in mind as we're setting out these goals and just thinking about them, our responsibility as policy setting, policy makers in terms of the regulations. So every time we do something in a regulation or ask the staff to take on something else or put something else out there, change the way that we take in information and put out information, we are creating,
I agree.
right? And we're moving the goalpost. So I think that this is wonderful to have this out there and have it in writing, as long as we also understand the responsibility and are cognizant of our responsibility for the ability to operationalize our dreams and aspirations of, you know, the wonderful regulatory system that we want to see.
Yeah, as usual, you've just been far more articulate than I was, but that's what I meant by, you know, this is a living document. It's meant to be an ongoing document to the extent that we put something on the executive director's plate and say, this is more important than the other things that you're doing currently. We need to make sure the goals change to reflect that. So we do have the exact responsibility that you just articulated. I completely commit to that.
Mr. Chairman,
Commissioner Flanagan?
I also want to say that some of these, while they're goals that we're giving him and he's expected to perform, the public is judging his performance. I mean, when you talk about getting back to a constituent, or you talking about a patient having their registration sent out or certification sent out in a certain amount of time, each and every day he's being held accountable to not only us, but to everyone that participates in this process. So I think that certainly to the fact that, you know, that we as commissioners can hold him accountable to these, I think he gets a daily reminder that if someone doesn't have their registration on time, they're calling and complaining, or they're calling to say what happened. And so that's a lot of pressure all year. And so I think that just to keep in mind that, you know, as Commissioner McBride said, we have our part in this.
Absolutely.
I think more so because we serve the public and not the private sector, and I've never been in the private sector, so I have no idea what that is.
A lot more fun. No, I'm sorry.
I don't know about that. I've had a pretty fun public life, I'll tell you. Just serving the general public is very different than serving a private business. And I think that each and every day we're judged as an agency on the performance. And so I think that, Sean, you know that these goals are here to guide, but each and every day you have to pivot and kind of deal with what comes at you, and how many people in this room try to get to you on a daily basis. So I think just to keep that expectation out there that the public they feel that he's accountable to them as well.
I'm sure that's true. I won't get into the debate about which is more fun, private sector or public sector. That would not serve anybody's purposes right now. But I will say in the private sector, while it's not every citizen of the state, you have external constituencies to whom you are responsible that you hear from on a regular basis. And oftentimes it's not just words, they vote with their feet. So yeah, I respect what you said and I agree with it, but it's also true in the private sector. Commissioner Doyle.
The advantage of going last is that everybody has already said pretty much everything that was.
Yeah, but you can rephrase it far more eloquently.
No, I doubt that sincerely. I would just echo just some themes that other people have said, that these may be goals that we're expressing to the executive director. I think some are more aspirational than others, depending on what time period we're talking about here. But I think I'm going to turn around and put additional pressure on ourselves. He needs our support in getting, especially a few of them, done. And I just want to reiterate how much he has accomplished in that 2 years and how much more needs to be done in a relatively short period of time.
I'm sorry.
That's it.
Okay, so first of all, I completely agree with those comments. I really just want to make sure I'm being very explicit about the living nature of this document, which is that we do need to commit as a commission to keep talking about this and to give Sean the opportunity to say, well, I'm not going to be able to do this because you just threw this at me, or to do this, I need this specific help. It's got to be a two-way street and a continuing dialogue and addressing the concerns that I think all of you have very legitimately raised, but I still think that's a really important process. So I think it's important to have a set of goals and to realize that circumstances change, but to keep it as part of an active dialogue, an active two-way dialogue. And Sean has every right, and I hope he has every intention, to say, I need your help to do this, or I can't do this unless you do these specific things to help me accomplish this goal, and we have to be responsive. We either have to do what he asks us to do or let him off the hook. but we'll have that conversation on an ongoing basis. Commissioner Title.
I know I'm not supposed to raise my hand.
No, it just gave me a reason to give you shit. Excuse me, to give you a hard time.
It really has been a long day.
It has
been a
very
long
day, and I'm sorry that my, keep going.
Commissioner Title.
Commissioner Title, the floor
I
is
was
yours.
looking for the interpreter to see how that got interpreted. I know.
The floor is yours, Commissioner Title.
So, so what I especially appreciate about these goals is that they are very public-centric, and especially the first three, it takes into account what the public is looking for from you, from us. But that leaves out a lot. There's so much that is implicit in these goals that we haven't talked about, but that you would need to manage in order to accomplish them, like dealing with the five of us, dealing with the public, dealing with the staff and the management. And so, one, I just wanted to acknowledge that. And then also just on that note, and acknowledge that you've done an excellent job with all of those unwritten things so far, in addition to the written goals. But also that I think it's incumbent upon you that as you look through the goals, if there are things that are blocking you, and things that the five of us need to do differently, for example, not changing the goalposts so often, we need to hear that, whether privately or part of this formal process. So I just want to explicitly invite that.
Thank you, Commissioner John. Any other comments? I would like then to ask for a motion with all of the commitments that we have made to ourselves, to Sean, that we've asked Sean to make, with all that embedded, to accept these goals for the executive director as a living document, but as the basis by which we'll evaluate where we are at the end of this fiscal year. So can I ask for that motion, please?
So moved.
Can I have a second? Thank you. Let the record show the motion was made by Commissioner Title, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show that the motion was unanimously approved by the commission. Thank you very much. I thought, by the way, this was a really good conversation. Sean, I hope it wasn't too painful for you. But I think we got into the nuance of why we're doing this and what the benefits are, but what the mutual requirements are to make this work. So
I just have one question. If we just took a vote on this and you said it's a living document, are we going to have to vote every time it changes?
I'll ask General Counsel for her opinion on that. Well, first of all, I'm sorry to interrupt. I hope it doesn't change often. I hope it's just the basis for an ongoing conversation, but to answer her question specifically.
Could we delegate to the chair if we make modifications?
Well, no, I think it has to be a commission discussion, but do we have to take a vote every time it changes?
I think if you're changing his goals, yeah.
Okay.
But I really do hope that we have an ongoing dialogue, but it's not a frequent occurrence, but it's certainly not an impossible occurrence. Okay, there's one last agenda item that is also related to performance management, and this once again puts Sean in this bizarre situation of having his personal life discussed publicly, which is compensation. Now, compensation is for a government employee is public, so Sean's compensation is known, and if we do make an adjustment, it will be known, and we will vote on it in public. However, I would like to ask for a motion to go into executive session for a short period of time to talk about this, Sean's compensation, and I'm using exemption 2 from the open meeting law, which allows us to use executive session to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. What I would like to do is go into executive session with just the 5 commissioners initially, plus legal, to discuss what we feel is appropriate, if anything, to adjust Sean's compensation. Once the 5 commissioners have come to agreement on that, then I would like to invite Sean also into executive session to negotiate. And then, based upon that the outcome of that negotiation, we will come back into public open session and vote on compensation for the executive director. But I'd like the conversation about our negotiating strategy as a commission and Sean's participation in that negotiation to be done in executive session. General Counsel.
Chairman, may I respectfully suggest that the Chief of Staff and my Associate General Counsel come into the session as well, so that appropriate notes can be taken in session and have support?
I'm not sure I understand the chief of staff. I believe general counsel and I believe a legal assistant for the purpose of taking notes. I'm not sure that I understand the rationale for a chief of staff.
Well, I think, in order to ensure that the commissioners have what they need, but ultimately it's your call.
Yeah, I don't feel strongly. I'd rather keep it to a smaller group. So my request is that I would like to have a motion to go into executive session for the purposes I just articulated, including for the first part of that session, the general counsel and a legal assistant, and then in the second part of that session, the executive director joining us. So can I have that motion? And just before I'm sorry, my intent would be, once we are done with executive session, to reconvene in public section to take a vote on compensation for the executive director and adjourn after that. So can I have that motion, please?
So moved.
You have a second?
Second.
So let the record show Commissioner McBride made the motion, seconded by Commissioner Doyle. All in favor?
I think it has to be a roll call vote, too.
Oh, I think this has to be a roll call. Thank you very much. Commissioner McBride? Aye. Commissioner Doyle?
Aye.
Commissioner Hoffman? Aye. Commissioner Flanagan?
Aye.
Commissioner Title?
Aye.
Thank you. We are in executive session, but we will reconvene in public session to have a vote on compensation and to adjourn. We're doing the executive session in the back conference room in our office on 13. Valerie, as we just discussed, would you care to make that motion, Commissioner Doyle?
Actually, General Counsel, could you read the motion out for me?
Sure.
The motion would be for the commission to authorize the chair to execute the agreed terms, specifically compensation in the amount of $196,000 resulting from the commission's negotiations, which will enable the continued and successful employment of the executive director, Sean P. Collins.
As stated by the General Counsel, so moved.
Okay, can I have a second, please? Let the record show that the motion was made by Commissioner Doyle, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show that the commission unanimously approved the motion. Thank you very much. Before I adjourn, or ask for a motion to adjourn, let me just go through the upcoming public meeting schedule. Our next meeting is December 19th at a location to be determined in Worcester. The following meeting of the commission will be January 16th, 2020. And that will be in Union Station, our offices in Worcester. There being no further business before the commission, I would like to ask for a motion to adjourn.
So moved.
Have a second? All in favor?
Aye.
Let the record show that we are adjourned as of 48 on the 7th of November, 2019. Thank you very much.